May I please, Your Lordship? Lordship, I beg to mention item number 54, Lordship. Lordship, here there are some subsequent development, Lordship. In fact, we were paid some amount, Lordship. And in this regard, I have to take some instruction from the client, Lordship.
Item
54, Lordship.
54,
54, Lordship.
the request of learned counsel for petitioner matter stands adjourned for 3 weeks.
Obliged, Lordship.
May I please, Your Lordship? Lordship, item number 59 is a hearing matter, Your Lordship. Records were called for, Your Lordship, on last occasion. They have not come, Your Lordship, the records.
Have you informed the other side?
Lordship, we have informed the other side.
Item 59,
59.
at the request of learned counsel for the respondent, MS
Deem.
D. Mutahari, matter stands adjourned for 3 weeks,
Lordship.
enabling them to call for the records
Lordship.
as directed. Is informed that is submitted that the counsel for the petitioner informed. Please take on.
May it please, Lordship?
Obliged,
I
Your Lordship.
beg to mention for listing a matter on 1st May.
What is the matter?
It is a matter for compassionate appointment,
Fresh matter, new matter, old matter?
pending matter.
Compassionate appointment is not before this bench. Compassionate appointment is not before this bench. The items, subject matters are listed, are shown in the list. You mentioned before appropriate bench.
Hello.
Yes.
May I please, Your Lordship? I beg to mention item number 52 of today's list, Lordship. Lordship, in this case, department should file a affidavit in opposition, Lordship. So, we have already informed the other side also, Lordship. Finally,
52.
52, Lordship. 2 weeks time may be granted, Lordship.
Your name, please?
T. Thakuria, Lordship.
I'm for the petitioner in item number 52, Your Lordship.
You are for the petitioner.
I'm for the petitioner.
I am for the secondary education department, Lordship.
I'm for the petitioner, Your Lordship. I'm an
So you want to file what?
Affidavit, Lordship.
On behalf of the department?
Yes, Lordship. So 2 weeks time may be granted.
Yes.
Lordship, may it not be 2 weeks in that case, may it be extended a little more because I'm an outstation counsel. Your Lordship.
Item 52 at the request of learned counsel for the education department.
Yes,
Mr.
secondary education. T. Thakuria, Lordship.
T. Thakuria. It adjourns for 4 weeks, enabling
6 weeks.
6 weeks. All right, 6 weeks. Enabling them to file the reply affidavit, a counter affidavit, and the petitioner may also file a reply affidavit and be listed thereafter.
May I beseech Your Lordship that the copy of the affidavit be served upon me prior to the.
I don't know that you you arrange with the council.
Before filing.
You got 6 weeks time to deal with it.
Great.
Yes.
Great.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention for listing. Last date of
What
listing.
is the subject matter?
Subject matter is removal from service.
The removal from service is not here. Before appropriate bench.
Lordship.
May it please, Your Lordship. Lordship, I beg to mention item number 37, my lord. I am for the petitioner, my lord. My lord, kindly pass over the matter for today, my lord.
Item 37 at the
Yes.
request of learned counsel for the petitioner, matter stands adjourned for the week.
I am deeply obliged, my lord.
Be listed after a week.
Please, Your Lordship, with the consent of the other party, I beg to mention item 36.
36.
Yes, Lordship.
You are for?
AKA Singh.
36 also similar matter. Adjourned after a week.
Obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 43 with the consent of the other side.
You are for the
Respondent 7 and 8.
respondent 7 and 8, item 43 adjourned for 3 weeks.
Obliged,
The
Your Lordship.
consent of the council for the petitioner has been.
May I please, Your Lordship?
Two sides.
Lordship, item number 39.
Yes.
Adjourned for the day.
Which matter?
Item number 39.
39. You are for whom? Petitioner, respondent.
Petitioner.
Petitioner adjourned for 1 week. Yes.
May it please, Your Lordship, I beg to mention for listing of a WPC on 3rd May.
What is the subject matter?
Lordship, this is a promotion from grade 4 to grade 3 in a college.
Before appropriate bench, not before this bench.
Listing, I am praying for listing of a, my lord, pensionary matter.
Pensionary matter.
Pension matter, bench to matter.
French, fresh
Yes.
matter or new matter?
Non-payment of family pension matter.
New matter or fresh?
No, my lord, old matter, my lord,
Old matter, then
2020,
we'll have it on 29th
29.
April.
Obliged.
Yes,
We have filed the reply. I think it has not come. We have filed an affidavit in opposition and we have filed the reply.
you have filed a reply.
Yes, Lordship. Their allegation is that they have started the proceedings. But in the whether it
Reply,
is 90
reply,
days,
reply is not available.
yes, my lord, reply. Let it come, my lord, on Monday or Tuesday.
It is submitted that an affidavit in reply has been filed to the petitioner, however, is not available. The case record, matter be listed again on 6th of May. 6th May,
Because
6th May.
Published.
Mr. A. Chakraborty, Mr. S. Dr. Yes, item 2. Instructions, any?
Petitioners were supposed to get the instruction.
None appears for the petitioner when the matter is called up. Let's then adjourn. We listed next week.
May it please your lordship, will you kindly grant me some time to file my reply?
Sorry,
Grant me some time to file my reply.
MSN Begum, Learned Counsel for the petitioner. Any objection?
No objection, my lord. It is necessary to adjourn. Date may be fixed, my lord.
Praise for further time to file reply affidavit. Matter be listed after 3 weeks. Mr. A.K. Dotto appears for the respondent.
No,
Must oblige, Lord.
No
Lordship,
fixed date, let it come.
Lordship,
After
interim,
3 weeks,
interim may be
interim order passed early will continue.
interim here.
Lordship, here in this matter, I have received instruction and file my affidavit.
Mr. D. Upamanyu, standing counsel, held submits that instruction the company like to make the report. To be listed again after 3 weeks.
Highly obliged. I'm for the AG.
Mr. B. Sharma.
Highly obliged.
May I please, your lordship, in this matter, lordship, instruction is sought for lordship.
Lordship, the instructions are awaited, your lordship. Pray for more than 2 weeks' time, your lordship.
Then we'll issue notice here. We'll issue notice.
Lordship may also, instruction may call for.
Right, MSD.
That may be fixed,
Lordship. Council prays for further time to complete the instruction. Matter be listed after 3 weeks.
Lordship,
3 weeks.
lordship.
Mr. C. Bhattacharya
That may be
listed after 3 weeks. 27th May.
Obliged, sir.
May I please your lordship, matter is regarding transparent. So last thing under the director being instructed on the department.
My lord, I have received instruction. My lord, here, my lord, the earlier notification was modified and he was reposted at Patrakandi Education Block. my lord.
What is under challenge?
Lordship, we have selected the last transfer order date in lordship 28/2/2024, lordship.
Where is that order?
Lordship, page 22, lordship. Lordship, 11%, page 24, lordship, last portion, lordship. In the interest of public service as per the latest ECI guidelines for ensuing Lok Sabha election, so and so has been hereby transferred and posted the BO Gobodo Education Block. Lordship, petitioner has transferred after 15 days completion of the earlier transfer, lordship.
When was this order issued?
Lordship order issued on 28/2/2024. Lordship earlier order was issued on only 5/2/2024. Lordship. Thereafter, petitioner was joined in the
Wait. What is the, which order was modified?
That, my lord, 13/3/2024.
Where is the 13.3?
13/3, my lord,
It's 13, there is no order. First order issued on 5/2. Second order, Lordship 28/2. In a period of 15 days, Lordship.
Where is 13.3 order? What 13.3 order? You have to cross-check your instruction with the fact.
yes. My lord, kindly take up on Monday. Take up on Monday. Kindly take up on Monday, man.
What Monday you get your instructions? Okay. Take, elementary.
Yes.
Elementary. Type. Or going.
Lordship, P. Guhai, Lordship.
Be going. After should be.
Lordship. Interim order earlier.
Interim order passed 30 bit.
Must.
Yes.
Can it be taken after some time, my lord?
Why?
There was a direction to obtain instruction, my lord. My lord, it's coming, my lord.
Let it be next week.
My lord.
Matter be listed again on 3rd,
My lord.
by which time the government, standing council elementary and government advocate will take instruction.
My lord.
Will be Chakraborty appealed for account. On 3rd. We had given some time, somebody prayed for some time. Health department prayed for some time. We had not fixed a date after 3 weeks. 27? 27. What was the item number?
4, my lord.
4. 27.
Pass over the time.
Not timing. Matter adjourned to be listed next week. Okay. Is there any interim order?
There is an interim order operating in their favor, Your Lord.
Oh, in their favor.
In their favor. Can it be on Monday, Your Lord?
Monday.
Monday, Your Lord.
29th. List on 29th.
Okay. All right.
Yes.
Now, this was a army personnel, my lord, who was entered in the service in the year 1986, my lord.
2016 you are discharged.
My lord.
Then why have you woken up now?
You can see page 43, my lord. In the meantime, we communicated to the department, my lord. After more communication, my lord, then department issued a letter, my lord. Page 43, annexure 8, my lord. DD number so-and-so, Abdul Hanan Rajbodhuya, Masan so-and-so address, my lord. Grant of one-time lump sum compensation of disability element. Please refer to visit this office 30th January 2024 as entered serial number so-and-so. You are enrolled in Assam Rifle 3rd May 1986 and retired from service on 1 June 2016. For retirement pension, the details of your medical category and disability status at the time of discharge from service are as shown as table below. Now, my lord, what happened? The petitioner was discharged from service on the ground of P3, P424 miles. If he Lordship, discharge of service P under P324, then he is entitled to disability pension or lump sum pension.
Yes, Mr.
My lord, may kindly peruse page 42, Lordship. 42.
But why have you come after so many years? What were you doing?
Now, due to Lordship, they have to have this impugn order, my Lordship, they called the petitioner. They asked the petitioner, my lord, to appear.
Page 42, Lordship, CL number 2, Lordship. Extreme right, Lordship.
Yes.
Class of pension, Lordship, voluntary, Lordship.
Oh,
Voluntary, Lordship. And so, Lordship, page 43 was issued, CL number 3, Lordship. He is not invalidated, Lordship, due to the medical ground.
you're not eligible.
Lordship, he is not invalidated in the
Where
medical.
is the medical board report?
Lordship, can you see page 22, my lord? They could not decide it, my lord, whether this disease under category of permanent disability or non-disability, my lord.
They cannot decide, then how can the High Court decide?
Let them file affidavit, my
Why,
lord.
what will they file? Where is the medical finding?
Lordship, medical board proceeding.
Category P3.
P3, my lord.
Hmm.
That is permanent P3 means, my lord, permanent disability, my lord.
You are suffering from TB.
TB, my lord. The two diseases, my lord, is suffering from. One, Lordship, TB, another is sarcoidosis.
What is the meaning?
Lordship, the medical terms, I am not.
You don't know. Who will know?
They also could not decide it, my lord. They sent the medical board, Lordship, kindly see, I have annexed the last page, my lord, 49, my
Where
lord.
is the order of discharge?
This page 42, my lord. This is the that one.
Forty-two.
My lord.
No, this is a different form. You were released from the service.
My lord.
There will have to
This
be an
time was
order.
another certificate, my case page 35, my lord.
Where is the order? Come to page 37.
My lord. Date of Lordship.
Page 37 starts from
Date of
page
discharge was
35, Lordship.
13 May
Page
2016.
35, Lordship.
Yes, yes. Come to page 37.
31, my lord.
37, serial number 4.
Close.
Serial number 4.
My lord. Discharged by order so and so.
Where is that order?
Dismissed.
14 January
My lord.
2016. Where is that order?
Even Lordship, my lord, may kindly peruse page 37, Lordship, regarding disability, Lordship, there is no Lordship.
That's right.
Lordship.
Therefore, we want to see the discharge order.
Lordship.
And this order is now not available with us, my lord.
It is not available. What can be done? You apply under RTI or something.
My lord.
But he is served for 30 years.
Lordship. So he is getting the pension, Lordship.
He's getting pension.
Lordship.
Yes, my lord.
Then
He
what
is
do you
getting
want?
pension, he wants, Lordship, the
Lordship.
disability pension, Lordship.
Which is more.
No.
Lordship.
Not disability. Therefore, Lordship, they issued this letter, my lord. Petitioner is actually, he is entitled to disability pension, my lord.
He wants disability pension, Lordship, but
He wants that letter has rejected your prayer.
No.
Page number 43 has
Okay.
rejected. What are you saying?
paragraph 3 is very specific, Lordship. Since you were not invalidated out from service on medical ground, Lordship, you are not eligible for disability pension, Lord.
You may be eligible for lump sum compensation
Yes, my lord.
in place of disability.
Yes, my lord.
And it's
But
depend
you are-
upon the Lordship, the percentage of disability.
Either
also,
Lordship,
Lordship.
Who will
disability.
decide?
Lordship.
Who will decide?
It's by the medical board, Lordship.
So you'll have to be constituted.
Lordship.
You get your instructions here.
Lordship.
If it can be done, then see if
My
there's
lord.
anything. That may
Otherwise,
be really.
and he has also appeared, Lordship, the board, Lordship. No, Lordship,
No, pursuant to this letter.
Lordship, he has appeared, Lordship.
Ah,
Pension review, Lordship, page 9, page 44, Lordship.
40,
no, this.
41, not
letter-
42, 45
letter
and
is of
42.
30th January.
Lordship,
He appeared before the board 45 and 46, my lord.
Lordship. 45 before the Assam Rifles, Lordship. Then
He
it was,
appeared.
Yes, my lord.
then it was recommended to the Lordship. Nigrim's Lordship, Nigrim's also Lordship says that there is no any report regarding disability
Not
part.
decided, my lord. Army hospital.
Disability part 48, Lordship. Nigrim also not decided,
What is the benchmark?
Lordship.
For
40, Lordship.
40.
40.
What is his disability?
Death percentage also not given by the Nigrim's Lordship. If his disability, Lordship, then Lordship, the discharge order itself is reflected, Lordship. Yes, because medical board recommended disability pension when it was discharged from service, Lordship. And page 10, Lordship, of annexure 10, page 50, Lordship. He says that one representation was, Lordship, sent on 22/2024, Lordship. My lord, may kindly peruse, Lordship, last page, Lordship, 52, Lordship.
Hmm.
This is the, Lordship, postal, Lordship, the receipt, Lordship.
Hmm.
It says that, Lordship, that particular representation was sent from counter number 2 on 8/4/24, Lordship. And he has annexed it, Lordship, by stating in a paragraph, Lordship, it is sent in 22/2024, Lordship. And no signatures also there, Lordship.
No, 28th February, by the time he sends, must have reached April.
No, Lordship. This is the postal receipt,
So
Lordship.
it says what?
Postal receipt regarding sending, Lordship.
8/4.
8/4.
So this February representation, he sent it in April.
Eight.
So
Lordship may issue notice, Lordship. I will reply, Lordship.
all right, hard.
Lordship may issue notice.
To notice.
Discuss
Mr.
with you.
P. Gogoi appears for all the respondents.
এখন কি
Sir,
represent হবে?
just our extra copies we furnished. Learned standing up. Learned CGC to obtain its instruction. We listed up.
I'm praying for my lord, the petitioner, he retired on 31/3/2016. Benefit of ROP 17. It's covered by my lord, many judgments of this court. One of the judgment may I produce my lord at page 109. Your lordship judgment is also there. Order is there in division bench, page 109. Same prayer, my lord, I would pray in this case also. He retired on 31/3/2015.
Yes. What do you say?
Lordship, there have been some developments. We are not opposing the prayer. The joint consultative committee of the chairman of the three companies, they held a meeting here, Lordship, on 27th of February. So as of now, across the three companies, there are 131 similarly placed persons, Your Lordship. So the total financial involvement on the pension fund will be around 21 crores, little more than that. So if we are agreeable to this, we are not opposing the prayer, but we may be granted, we'll process the application for revision of pension straight away, but the arrears that have to be paid, Your Lordship, only praying that we may be granted liberty to pay that amount in equal installments across 3 years, across 2 years.
Yes.
I have a copy.
This is 2 years, but to others they have already given.
No, the arrears have not been paid.
Arrears have not been
We have revised their pension. The arrears that they will be paid, that will be paid in installments across 2 years.
5 installments.
My lord is all right.
Yes, Your Lord.
In a span of 2 years.
Yes.
Okay. Very well, then we dispose it of.
My lord.
Yes.
In terms of the order at 110.
My lord.
along with the liberty to grant to areas within a span of years in 5.
Deeply obliged.
Sorry, Mr. Pizza. For APDC.
Yes, for respondent numbers 1, 2, 3, and 5, your lordship. 1, 2, and 3.
4 and 5. The Hard Learned Council issue notice returnable 4 weeks. Yes, we issue notice.
That was what I was going to say.
Issue notice, Mr. P. Bharadwaj, the petitioner, issue notice. Mr. Pegu for respondents, for all respondents. Yeah. For education, one,
Accountant General is there.
for number 1, number 2, number 3, number 6 and 7.
Finance.
Mr. C. Burua for Accountant General, number 5, Mr. Toliha for Finance, number 2. Since the standing councils represent the respondents, notices are waived, our extra copies will be published within a period of 1 week.
One small claim, my lord. In the approval which is annexed here, my lord, there are other persons also who have now approached this court in pending. That is WPC 1119 of 24.
Let it come back after the returnable date, you renew your.
My lord. Okay.
May I please, lordship? Lordship, matter may be passed over timing, lordship.
Time being. Yes,
Also, here we have filed an interlocutory application for modification of the order dated, lordship,
or let it be listed on first
on
of May,
lordship.
at the request of learned counsel for the petitioner, matter be listed. You are appearing for the petitioner.
Yes.
Your name,
H. Islam, on behalf of B. Sinha.
H. Islam, on behalf of Mr. T. N. Sharma.
Elementary.
Elementary education.
I'm sorry, but in this case, inadvertently, my lord, as per the order 28/2/2020.
Is it infractuous?
No, not rest, my lord, the steps has not taken, only 3 days time only, my lord.
Mr. P.
From 8
also,
to 12.
learned counsel for the petitioner is granted 1 week's time. 2 weeks' time.
My lord, 1 week,
1 week's time to take steps on respondents 8 to 12
8
by
to 12.
registered post AD as well as by usual courts. Matter be listed. Thereafter, Mr. C. Borua appears for Accountant General.
6 and 7, my lord. 6 and 7.
6 and 7.
My lord.
Mr. A. Chakraborty for
1, 2, and 3.
respondent 1, 2, and 3. Mr. Cholia for respondent 4 and 5. List accordingly.
Master.
May I please, your lordship? Lordship, may kindly take up the order dated 23/1/2024. Mr. B. Chaudhary, learned counsel for the respondent, submits that the affidavit on behalf of the respondent in the matter is ready for filing and would be filed within 7 days, lordship. This is the order of 23/1, lordship.
Some more
And 4 months has left.
changes in the affidavit.
Lordship, changes in, just now I have received, email, Lordship. I pray for, 2 weeks, Lordship.
Lordship, otherwise date may be fixed, lordship.
Yes, Lordship. I've got-
It's remanded that matter, lordship.
Mr. B. Chaudhary, learned counsel appearing for which department?
For BTC, Lordship.
For PTC. Means that the affidavit requires further time. The affidavit that he requires further time to file affidavit, it plays for 2 weeks time. Mr.
N.K. Sharma, Lord.
N.K. Sharma.
N.K. Sharma.
N.K. Sharma, appearing for the petitioner, submits that the matter be listed on a fixed date.
Lord.
Accordingly, the.
10th of May, Lord.
Not 10. Matter be listed again on 27th of May.
4 weeks. They are seeking, Lordship, 2 weeks. Lordship.
2 weeks, we are giving them 2 weeks. But
Then Lordship may record that invariably file, Lordship, before the next date, Lord.
if they don't file, we can't compel them to file. We'll proceed with the hearing.
Lordship.
Or we can have it on 24th.
Yes, sir. Lord.
24th.
Lord.
If it is made clear that in the event the affidavit is not filed, consequential orders may be passed by.
Lord. Deeply obliged.
By this requisition, by this, I am seeking the retirement benefit of my deceased mother. I am the daughter of my mother and class 1 legal heir of my deceased mother. But considering the fact my father filed requisition before this honorable High Court for releasing the death cum retirement benefit to my father, and Honorable High Court passed an order directing the respondent to release the death cum retirement benefit to my father. Annex 2, my lord, kindly see. High Court order, page 12.
Yes.
Page 12 to 11%, page 13.
Yes.
But on the basis of this order, a major portion of the death cum retirement benefit was released to my father, my lord. Annexure, kindly see annexure 3, my lord. 3,02,433 rupees already released to my father, my lord. And remaining portion, 6,30,201 is yet not released to my father. So I am entitled for the death cum retirement benefit of my deceased mother. So this is interim order dated 28/6/2019.
There is an order of the court pursuant to which it was released.
Yes.
If you filed a review against this order,
No, I have not filed anything.
because so long the order stands, the benefit will have to be released.
Yes, already I have made objection to the authorities, my lord. For that petition.
That will not help. You see, come to page number 13.
Yes.
Come to page 13. See page 13.
Hello?
Come to page number 13.
13, that is the High Court order, my lord.
Yes. Read the third paragraph.
Public counsel for the petitioner categorically states before this court that there was no departmental inquiry pending against the petitioner's wife, nor any criminal investigation. The petitioner had filed the representation including on 19/12/2016 before the authority for the aforesaid benefits, but has not been given any positive response. That apart, the petitioner had submitted all relevant documents to the authorities concerned, and as such, there is no reason why the aforesaid outstanding dues of the wife of the petitioner should not be released to the petitioner. In that view, the matter of the present petition is disposed of with the direction to the respondent authority to examine the claim of the petitioner, and if all relevant documents are in order, the provisional fund, leave salary, gratuity, etc., may be released immediately without any further delay.
So this order will have to be modified.
I have to say, I did not challenge the order because I do not know about the order of the Honorable High Court.
That's all right. Now you know.
I am, at present I am,
So you have to file a review in this order.
maybe
You file a review.
direction will be given to
No, we don't give you direction. You are at liberty to file a review.
all the, by, against this writ petition, my lord, a order is maybe passed, directing me
I
to
cannot,
file,
I cannot pass. It is by bench of equal strength. It is by it is an order of a coordinate bench. I cannot set aside an order of a coordinate bench.
No.
You have to go in appeal or you have to file a review.
that a direction may be given.
Third learned counsel for the party. This writ petition is filed by the petitioner who claims to be the daughter of late.
Thoritri Das.
What is the name?
Mother's name is Thoritri Das.
Thoritri Das, who superannuated. She superannuated or she died while in service?
Died by 17/6/2016.
In service.
While in service.
While in service.
She was engaged as, she was employed as a helper in Nityananda Center for Assam Khadi and Village Industries Board. She died in harness on 17/6/2016, leaving behind the petitioner and her father, Sri Madhusudan Das, as a legal heir. So the petitioner claims to be a legal heir, class 1 legal heir of the deceased mother, as per law. Stop. However, to her surprise, she came to be informed that her father, Sri Madhusudan Das, preferred a writ petition before this court, being WPC 2162 of 2018 before the Guwahati High Court. So, the coordinate bench by order dated 13/3/2019 disposed of the writ petition with the following order. Extract order, page 30. In pursuance to the order passed by the coordinate bench in WPC 22, rupees 302,433 has been released to the husband of to the father of the petitioner by the department. So, the further amount of rupees 6,30201 has been sanctioned but not yet released. So, the learned counsel for the petitioner submits that the father of the petitioner suppressed material facts without disclosing that the petitioner is a daughter and is also entitled to the pensionary benefit or in respect of her late mother, so late so and so, and suppressing this material fact, the earlier order of the court was in view of the suppression of the material fact, the order of the court passed. The counsel for the petitioner submits that this order was not known to him earlier, and therefore he would like to file review against this order by withdrawing the present petition. Prayer made is allowed. The petitioner is permitted to file a review against the earlier order dated with WPC 20, and the respondents are also the petitioner is also permitted to apprise the respondent not to release the balance amount in favor of the.
There is a interim order to that effect. In this,
there is an interim order.
Yes. Not to release.
The respondent department is also will also inquire into the matter before release of the claims in respect of her dead mother. It also inquire into the claims of the writ petitioner vis-a-vis that of her father before proceeding to release. writ petition accordingly stands dismissed on withdrawal.
If I may mention one thing, they know, the wife has made the husband as the nominee in the pension paper.
You examine it.
Yes. Now the interim order that will be published.
Right.
My lord, this petition has been filed by the second wife and two daughters of the deceased pensioner, my lord.
Second wife has no claim.
My lord, exactly. And now, my lord, my claim, my lord, petition number 2 and 3, they are the, my lord, daughter of the deceased pensioner. My lord, pensioner died, my lord, in 2019, my lord. And after his death, my lord, entire pensionary benefit receiving by the first wife, my lord. Now, our claim, my lord.
On what basis you are making this claim? What basis you are making this claim?
My lord, we are the, my lord, two daughters, my lord. I have annexed their certificate, my lord.
Any legal aid certificate?
My lord, your lordship kindly see page 21, my lord. Page 21, 11%, my lord, page 22, my lord. Mollika Burman, my lord, below person, my lord. Mollika Burman is the first wife. Jitu Burman, he is now major. Number 3, my lord, Basavati Burman is the daughter.
Yes.
My lord,
yes.
page 22, my lord. My lord, here is a PPO, my lord. My lord, here in this, my lord, their name has been mentioned, my lord. And on the other hand, I have also annexed.
What is your name?
My name, my lord, number 5, Orpita Burman, and number 3, Basavati Burman. And on the other hand, I have annexed the certificate also. My lord.
This is what? This is the PPO.
This is a PPO, my lord. My lord, my question, my lord, whether the children, my lord, I mean, my lord,
They are unmarried.
My lord, unmarried. My lord, I have two judgments, my lord. One, Honorable Supreme Court judgment, and another, my lord, our High Court judgment, my lord. You lord, kindly clear. The children coming from second wife, they are entitled.
They are eligible.
My lord.
What is it done here?
Lordship, no, because of the nomination from. My lord. Lordship, otherwise, money is to be paid, the amount has to be paid to only one person, and that one person happens to be the first wife, your lordship. But she is supposed to take care of the others, your lordship. My lord, in Rameshwari Devi, my lord,
Yes,
that proposition is not.
What is the pensionary benefit? The rules. There was an amendment in the rules.
Lordship.
Pension. What does the latest amendment say?
Otherwise, unmarried, your lordship is referring to the unmarried daughter aspect.
Release of pension.
Lordship.
Yes. Do you have it?
Lordship, yes, 143 years.
Second para.
2, your lordship.
That is the amendment.
Complaint authority shall issue orders appropriating the family pension. Yes, your lordship, in that view of the matter can be disposed of, your lordship. My lord, now, my lord, what happened, my lord? The first wife is not coming and contesting this case, my lord. On the other hand, he is correct, your lordship. Dusty service has also been refused to be accepted. So all these things have court has already noted.
Who is releasing the pension?
Uh,
Who is the pension releasing authority?
Treasury officer, my lord. Puri. No, competent for treasury officer. Competent authority,
Here,
my lord.
where the husband was working where?
My husband was working as my lord police constable, my
Police.
police only got. So page 23 otherwise is a representation. Based on that also, I think similar here can be done. Now, pension, my lord, pension money has been stopped, my lord. And my lord, nobody is getting money.
Heard learned counsel for the parties, this petition is filed by the petitioners, claiming their share of family pension in respect of late Ravindra Borman was who was employed as a police constable under the Home Department and was superannuated from service on 31/12/2020. So it is submitted that petitioner 1 is the second wife, petitioner 2 and 3 are the daughters of petitioner born after marriage of petitioner number 1 and late Provisional. Learned counsel for the petitioner has referred to the has referred to the particulars in the pension payment order, wherein the names of petitioner number 2 and 3 are reflected as in the particulars of the family members as serial number 3 and 5. So it is submitted that the claim of the petitioners have not been entertained by the authority, and the private respondent number 6, with the first wife, has been receiving the pension without sharing the same with the petitioners. So learned counsel for the petitioner has referred to judgment of the apex court, Rameshwari Devi reported in as well as judgment of the Guwahati High Court, Agartala bench, Anita Shi, in support of his contention. The only claim of the petitioner before the court is that the share of pension in respect of late Ravindra Borman, who was the husband of the petitioner number 1 and father of petitioner 2 and 3, has been denied to the petitioner by private respondent. So there are Mr. C.A. Mr. C.S. Azorica and counsel appearing for the respondents submits that as per the pension rules, the eldest surviving legal heir who's eligible to receive the pension is required to distribute the same among the other eligible legal heirs and also after their needs. And if the same is not done, and the said legal heir is duty bound, carry out the responsibilities mandated under the law. And affidavits have been filed by respondent number 3 as well as by respondent number 1. These affidavits do not throw any light on the position of law as to how the pension is to be distributed or divided amongst the legal heirs. A perusal of the relevant rules, the Assam Services Pension Bill 1969 reveals that an amendment has been brought into Rule 143 by notification dated 17th August 2022. So, by the same notification, the Rule 143 was amended with the following. Extract amendment that number. A careful perusal of the amendment brought in by the Assam pension rules reveal that the pension is to be paid to the eldest surviving in case of a government pensioner male, pension is to be paid to the eldest surviving widow. Stop. A further amendment has been brought in by insertion of new clause D in note 2 under Rule 143 that if the family pension recipient does not divide the amount among the other beneficiaries in equal share, and on receipt of such complaint from the eligible family member, the competent authority shall be ordered apportioning the family pension among the other eligible. This amendment has been brought in. It be squarely applicable to the facts and circumstances of the present case. So, it is settled law that children born out of second marriage are entitled to pension as has been held by the apex court in Rameshwari. Reference may be made in the relevant paragraph.
Nine.
Of the judgment rendered by the apex court. There are 9. Now, where the law is settled that the children of second born out of the second marriage are entitled to pensionary benefit, there is no question of denial of pensionary benefits, especially to petitioners 2 and 3. Petitioner 1 being the second wife is not entitled to any share of pension as the same is not provided for under the rules of 1969. In terms of the amendments brought into note 2 by way of clause D, the government is the competent authority is required to apportion the pension in terms of the in respect of the eligible member, the recipient of the pension does not share the pension receivable by the other eligible member. So it is submitted from the. Have you filed any representation or complaint?
My lord.
23 and 24, Your Lordship.
My lord, earlier I have filed my lord.
That may be treated.
It
It is seen from the readings that a representation has already been filed before the Superintendent of Police Kokrajhar District on 15th of March 2019. So, a similar representation is also filed before the Treasury Officer of 10th of July 2019 by the Commissioner. So, under such circumstances, the respondents, more particularly the respondents number 1 and 2,
Not sure. Yes.
will call for the relevant papers pertaining to the pension payable with respect of it and pass necessary orders in favor of the other eligible members who are entitled to receive pension, more particularly petitioners number 2 and 3, in terms of the clause D of note 2 under rule 143 of the pension rules. Upon such orders being passed, the apportioned pensionary benefits increase to the petitioners 2 and 3 as well as to the private respondent and public or any other. The entire exercise be completed within a period of 30 days from the date of receipt of a certified copy. With the above direction, the petition stands allowed. The above order is interim order, if any, will stand for.
Achha, maybe 45 to 60 days.
All right, 60 days. The date you-
My lord, only my lord, one line may be added, my lord. The pensioner died, my lord, 14 February 2019, my lord. My lord, since from that day, my lord, the first tribe is getting, my lord, pension. That may be adjusted, my lord.
Not adjusted, you'll get the future pension, no more adjustment. The petitioners 2 and 3, it is made clear that arrear of pension already released to the private respondent need not be adjusted. The petitioners who are 2 and 3 will be entitled to the pension henceforth.
Obligement.
May I plead, Lordship, and matter relates to non-payment of regular pension, my lord. Lordship will look into Annexure 2 case 10. Annexure 2 case 10.
Annexure 2 page
2 case 10.
10.
My lord, provisional pension was granted in the year 2012, my lord. I am directed to convey the sanction of the Governor of Assam to payment of provisional family pension at the so-and-so with effect from so-and-so who expired on 13/4/2010, while in service with effect from the issue of final PPO by the accountant in Assam. My lord, the regular pension has not yet been received by the my lord petitioner. She is getting the provisional pension, my lord.
Why it has not been released?
My lord, no instructions have been forthcoming, my lord. Directions may be issued to the commissioner straight away to process the pension papers post verification of the service records within a period of 2 months and thereafter forward it to the director pension for further adjudication.
Where?
End of matter.
Arch, dispose of direction of the commissioner, verify and examine the claim, thereafter make release the pensionary benefit. Till such time the pensionary benefit is released, the provisional pension which has been released will continue to be released. The entire exercise will be completed within a period of 6 months. Mr. D. Bhattacharya for Accountant General, Mr. P. Hendy for Panchayat. Panchayat. Mr. A. Chakraborty for Director of Pension. Director of Pension.
May it please your lordship. This petitioner is before your lordship challenging the rejection of the appointment on the compulsory ground. Basically, the rejection, your lordship will turn to page number 40. I'll just point out the There were grounds, 4 grounds were given, page 40. 40. I'll come to the facts later on. Rejection was on the basis of four specific grounds. Page 40 at serial number 26, second one.
Age
40.
40.
Serial number 26, the second person, Basab Ranjan Dev. This is annexure 9. Annexure 9. So,
Yes.
there are 4 grounds given, Your Lordship. Number 1 is applicant does not possess required educational qualification, that is graduation. 2, applicant's father has less than 3 years of service remaining. Number 3, applicant cannot be accommodated in any division in Assam. And applicant application was pending for recommendation for more than 2 years. Therefore, application span is forced. These 4. Out of these 4, the second one, applicant's father has less than 3 years of service, has been found to be ultra biased by this court. So it has been satisfied. So that part gone.
No. When was this order passed?
This order was passed on
Minus is 2019, Your Lordship, 23/12/19.
19.
So this setting aside has come later.
Later, it has come later, but that was
Your
not.
Lordship,
What has
it's
happened?
it
What has
got-
happened to the appeal?
No, Lordship, the stay has been continued, Your Lordship. I have the last order, if Your Lordship.
Stay means single judge order
Single judge's order.
has been stayed.
Stayed, Your Lordship.
Anyway,
And Your Lordship, we see last order, last to last order, 21/12/23, Your Lordship, regarding this issue, it has been already mentioned that this issue has been stayed by the Honorable.
Yes.
okay, fine. That is okay. That part will be decided. Now, the first part is that the order of this honorable, this is the third litigation before this honorable. So first, he was rejected on the ground that 5% quota has exceeded. So he cannot be accommodated. He came before this honorable court. There was a direction that, yes, if this is 5% is exceeding in a particular department, it should be on the basis of the whole of Assam, any other departments. So there was an order by the honorable court saying that, yes, you accommodated him in any other division or department or whatever. So that was not done. Most probably the order, the number 3 is saying that applicant cannot be accommodated in any division. Must be a ground for that. I don't know. We are not sure about it. Because the minutes, they will be knowing in the records whether on that ground or whichever ground it has been. Then the first one was education. Then this honorable court in earlier litigations have said, if the person is not a graduate or not qualified for the post of grade, he can always be accommodated in grade. So this is all that is there. First is there that he can be accommodated in grade 4, not in grade 3. In fact, the initial district level committee has recommended for grade 4, not grade 3. But they have decided to put him in grade 3 and then rejected him, saying that you are not a graduate. Fine. That is not correct. Then comes the second part, 3 years. Anyway, that is under consideration by the division bench. And then the third part, when this honorable court directed that you accommodate him in any other department. And that has not been. These are the 3 basic. Now the question is, your lordship will say the 3 years part, though that has been stated by this honorable court. I cannot argue because that final decision will have to come for that part. But the rest of the issues, your lordship will then take up the earlier order of the sum. That your lordship will find at page 32. There are 3 orders. This is the second order. Page 32, but it starts from page 33. In para 4, your lordship, para 3, the grievance of the petitioner is that though the petitioner application for appointment under the Dine Highness scheme was recommended by DLC in the meeting dated so and so, the SLC rejected the claim of the petitioner on the ground that it does not come under the 5% quota reserved for compassionate appointment, and also the petitioner is underqualified for the post of junior assistant, though the petitioner has actually applied for LDA. It goes without saying that before the SLC rejects any application on the ground of lack of vacancy, it is incumbent upon the SLC to examine the availability of vacancy in other departments as provided in paragraph so and so of the office memorandum dated so and so, in which it has been provided that if vacancy is not available in a particular department in which the initial proposal was made, the authority can examine the availability of vacancy in other departments paragraph 15 of the OM is quoted. Then the direction has been given. Further, the petitioner submits that he has applied for the post and not for the post of junior assistant, and he possesses necessary qualification for LD. The earlier rejection by the SLC contained in the minute of the meeting dated so and so. So far, the petitioner is concerned accordingly set aside. In view of the matter, this court is of the opinion that it will be appropriate for the SLC to re-examine the claim of the petitioner. Accordingly, the present petition is disposed of with the direction to the respondent authorities to place the matter before SLC to re-examine the claim of the petitioner in terms of paragraph 15 of OM dated so and so and mentioned above, and also in consider the claim of the post of LDA which exercise shall be undertaken in the next meeting with this. So here, your lordship, earlier, the rejection was on 2 grounds. Number 1, 5% exceeded, and number 2, underqualified. Now they bring in the 3 years and whatever it is. This order was very specific, said that no, you appoint him in any other case, and it was earlier order was set aside. In a sense, it seems to be some kind of a contempt also, because once you have decided that what your decision was wrong, it was set aside, you re-examine, and on the basis of the order given by the court, where the court specifically states that you follow follow 15, para 15, and appoint him in any other department. Fine. They should have gone through saying that yes, underqualification has also been set aside, saying that you can be, he is qualified for the lower post. So these 2 aspects already dealt with by the Supreme Court. Only they should have said that we have looked into in other departments. Maybe there is quota is there, not there. That is not specifically. So basically, one point remains.
That they have said, not accommodated in any division.
But I don't know how, what. No. So they have given that. They have said it cannot be appointed in any department in Assam. In what sense? I don't know. Whether there is no vacancy. They should have said that there is no other vacancy in any other department.
Not happily worded, but
no, we are also confused.
Except is that it will have to be interpreted. Yes, what is the meaning of any division?
No, that I
Page
think
number-
they require an instruction.
Serial number 3.
Three.
What is the meaning of that?
My lord, I am appealing for the department, my lord.
Can you throw light on the meaning?
My lord. The applicant cannot be accommodated in any division in Assam. Meaning thereby, my lord, they have gone through, there was no vacancy. That is what, my lord.
Vacancy where?
Vacancy, my lord, in PWD. My lord.
But the clause 15 does not restrict it to the
My lord, clause 15, these are all, these matters, my lord, I understand. But now Supreme Court has come up with all solutions, my lord, for this thing. Honorable Supreme Court has passed an order in Devabrata Tiwari versus State of Assam. That has to be, my lord, passed. He has to answer. Now that is the law set by the Supreme Court. Para 35.
I know that.
Categorical, my lord. These such cases are being, my lord, dismissed day in, day out, my lord. The Supreme Court has set a, my lord, guideline how to deal with such cases. My lord, 35. Considering it starts, my lord. My lord will just take a note that petitioner's father died in 2010. 14 years has sailed through, my lord, in between. 14 years. Now, my lord, I'm coming to here, my lord. Considering the second question referred to above in the first instances, regarding.
No, these are issues you consider at a time when you are first considering the case.
Yes. Yes.
No, my lord. What is exactly that is what I'm coming here, my lord. What Supreme Court has said, my lord.
No, Supreme Court has said this has been said before.
No, my lord. This
yes,
is
you'll have to explain how the financial hardships you'll have to overcome.
No, my lord. I'm just trying to read it. That is what, my lord.
Read. Satisfy yourself.
Further, my lord, considering the second question referred to above in the first instances regarding whether the application for compensation appointment could be considered after a delay of several years. That is the first question, my lord, came before the Honorable Court. We are of the view that in case
in a case where for a prolonged delay, either on the part of the applicant in claiming the compensation appointment or the authorities deciding such claim. So both the parties, my lord, the sense of immediacy is diluted and lost. That is what Supreme Court held. Further, the financial circumstances of the family of the deceased may have changed for a better since the time of the death of the government employee. In such circumstances, court or other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainful employment for some other sources. Granting compensation and appointment in such cases, as noted by this court in Hakim Singh, would amount to treating a claim for compensation appointment as though it was a matter of inheritance based on a line of succession, which is contrary to the Constitution. Since compensation appointment is not a vested right, and the same is relative to the financial condition and hardship faced by the dependents on the deceased government employee as a consequence of his death, as a claim of compensation appointment may not be entertained after a lapse of considerable period of time since the death of the government employee. That is what, my lord, 14 years has passed from, my lord.
Does it say anything new?
My lord?
This is what has been stressed earlier also. It's not nothing new. These conditions of financial hardship is there.
Exactly, my lord. 14 years has passed from, my lord.
But before
They
that, before that.
Yes, my lord.
Is the Supreme Court order binding only on the High Court or also on the department?
Binding on all the parties, my lord. All the parties, my lord.
Now, if it is binding on all the parties, very few findings that the financial hardship.
My lord, financial hardship, because, my lord, we have been providing them, my lord, with pension, my lord. That is their family pension they are getting.
No, Mr. Dor, we are dealing with this order.
Yes, my lord.
By your
hardship, my lord. Hardship, my lord.
You come to the order and tell us where it has been dealt with. Come to page number 40, serial number 26. Your department did not even deal with it.
My lord, that part, my lord, we have already given them family pension, my lord. They are getting it to deal with the hardship, my lord.
You will have to deal with it.
That is what family pension has been given. Let them say that they are not getting family pension, my lord.
No, it's not for them. You are supposed to do it pursuant to a direction of the court.
My lord.
There's an order of the court, pursuant to which it has been decided.
We have decided, my lord.
You have decided, but you have not. You have referred to this judgment, but you did not deal with the family financial issues.
Financial issues, my lord. We are providing them with pension.
Where have you said?
My lord, let them say that they are not getting family pension.
Not supposed to them. You come to the order of the court.
My lord.
There is an order of the court.
My lord, here we are.
Mr. Or,
my lord,
please make reasonable submission. This is not a fresh matter. This decision is pursuant to an order of the court.
Exactly, my lord.
Your officers had all the materials before you.
My lord.
Your officer did not go into the aspect of financial hardship. You have to question them. Why? If this is the ground which you are urging now.
No, my lord. I am now today. I am on the delay part, my lord. 14 years.
No, you show me from the compassionate appointment law or the guideline.
My lord.
That it is not applicable in cases of people who are getting family pension.
Oh, my lord. I am not on that. I am on what Supreme Court said, my lord. Supreme Court said that that period is diluted.
It's a general principle to be applied specifically to cases.
My lord, this is for compassion appointment, my lord.
Yes. But who is to take a decision about the financial status?
My lord, Supreme Court said that when they have been able to sail through this long gap,
correct,
meaning thereby they could sustain, and now
absolutely.
giving them becomes,
no,
my lord, it's diluted.
That is a
that
condition.
Immediacy is gone.
That is a condition you will look into in fresh applications.
No, my lord, no, my lord. The court is supposed to look into, my lord. That is what.
How will the court look in the absence of directive?
My lord, that 14 year is gone, my lord. In between, my lord.
You are skirting the question. There is a direction of the court. Have you gone an appeal, review, nothing?
My lord, we have considered, my lord.
So then that's what we are trying to say. You have considered. You while considering,
My
kindly
lord.
come to the order at page 33. Page 33,
My
you
lord, I'm-
rejected earlier on
My
the
lord,
ground
my
of
lord.
lack of vacancy.
My lord,
So this lack of vacancy ground was
My-
set aside
my lord,
and you were directed to reconsider it.
my lord. We have reconsidered, my lord.
I know, in terms of para 15.
My lord. There we could not find in any other division. My lord, so.
No. Para 15, that is again a query that you will have to answer.
My lord.
Is para 15 meant to be restricted only to the department or the divisions? Or does it comprise of all the administrative departments? Subject to correction, it refers to all administrative departments.
15 has been quoted, your lordship. It has shown that specifically page
It is already
34.
there in the order.
All departments. It said.
Take
all
up the
other
matter
departments.
with other departments and offices of the government. Have you done that? We are in respectful agreement with the directions of the Supreme Court, no doubt about that.
My lord, this part, I am appearing as standing counsel for the PWD. My friend is answer, he is appearing for SLC. Because there will be conflict, because that part, other departments, my lord, we are restricted to only my department. Other department, from SLC, it has to come, my lord, not from me, my lord. Because then, if I start arguing for both, there will be conflict. Because I can only say about my department, my lord. Otherwise, my lord, my stand is, my lord, that immediacy is gone 14 years. That is what Supreme Court is, my lord, is referring to. Either on the part of the petitioner or the authority.
Say that in the order, stopping. This is not something new. It has been there
My
in
lord,
earlier judgment.
this has come in 2023, this order.
No, there are earlier judgment.
No,
There are earlier judgment.
no, my lord, this specific direction was not there, my lord.
No. We'll show you. We will show you, we'll keep it on Monday, we'll come back, we'll help you with the judgment.
My lord, not, it was for petitioner was there, my lord, but not for,
We will undertake to help you with the earlier judgment.
my lord, that is not record, my lord. I will check, my lord.
But you're insisting that
No,
this is
no,
the
my
first judgment. There are earlier judgment. Mr. Matan, how do you recollect? There are earlier judgment. With elaborate findings that financial standing is one of the grounds. It was open to the department to take all this ground. But then there is an order of the court. That order has not been reviewed, not been appealed.
My lord, we have complied, my lord. How, we did not go for review only because we have, we have gone for compliance, my lord.
Compliance has been in terms of the order. You are directed to comply in terms of para 15. You can't say that we considered in terms of the department and comply.
My lord will then take a call, my lord. And my lord will just quote this judgments in the order.
The other judge.
My lord, that is my lord's prerogative, my lord.
But the problem is that this was
My
open to
lord
the department.
my lord may dispose it, this case, my lord. I
You
have,
will not dispose it. You will have to get the answers to tell us why para 15 was not done. Who is supposed to look?
that SLC will do, my lord.
Huh?
The state level
State
committee.
level committee, my lord.
He is only for the department.
I am only for the department, my lord. PWD, my lord.
Who's for the state level?
He is there, my lord.
One thing, your lordship is true, lordship, just correct, this instruction may be required, but the reality is that ultimately, your lordship, the 3 year unless and until this issue is sorted out, even assuming that we do a mistake also here, but 3 year issue is upheld by the court, then
If
ultimately, your
tomorrow's honorable division bench comes up that
that issue,
the set aside the single bench order, that 3 years, my lord, then this will again come into force,
then
my
your
lord.
lordship will see the last 3 orders of the.
No. 3 years, we are leaving it aside. See,
That is a vital thing, my lord.
No,
Because that is the
3
policy,
year-
my lord.
No,
We won't be able to consider, my lord.
One
If
thing,
if the 3 years is standing.
one
is
thing
there.
I would like to point out, he was not there earlier.
And
It has come
tell us,
back later.
please tell
Now,
us what is the rationale between these 3 years?
My lord, that is before division bench now, my lord.
No,
It's a
that is
sub judice.
before, we are not
I
asking
cannot,
you
my lord.
to- We are not asking you to take a stand. We are asking you what is the rationale behind
That,
3 years.
that was that was
Somebody's relative expired
my lord.
and the government servant has the government servant expired and he had less than 3 years or within 3 years.
My lord.
Is it a ground to?
That is the my lord wisdom of the government, my lord. They have taken a policy decision, my lord.
And that government you are representing or a part of it.
Yes, my lord. So that is what, my lord. There is under challenge and is before division bench. So I am, my lord, I cannot make any. In a court of law, I cannot, my lord.
Earlier, this was not there.
Lordship, may
Their
I
earlier rejection does not show that.
May I read out the last 6/10/23 order? Mr. Y.S. Mannan, learned counsel for the petitioners, placed reliance on the case of Bhaskar Kaur versus State of Assam, WBC number so and so, decided on so and so. In the said connection, Mr. Adhar, learned counsel for PWD, D. Bora, learned counsel government has submitted the state has filed an appeal before the division bench. So this was an issue which he himself had cited, saying that balance 3 years will not come. Now we are filing an appeal and this has been stayed, your lord.
That is an
So, your
order.
lordship, now he cannot
No, no.
now say that now this order
What?
now.
I'm not
when
saying
it was-
that.
When it was
Kindly
being-
let me-
when
let
it was
me-
being
let me
helpful
speak.
to him, he's citing this case, but now when we're citing the other case for.
Not submitted like
Not, I'm
No,
not
no,
submitting
we
that.
have-
I am.
no, 16, your lordship will see, kindly see the order.
Forget about the order. What I'm submitting there is important.
It is not his submission.
No, lordship, it is his submission recorded by the honorable court on 6/10/23.
Fine. So I can, is there any
His
bar to
submission
submit?
that Bhaskar Kaur is not applicable. That is not his submission. He says it is applicable.
But
But there is a stay.
Right, yes.
Fine, there is a stay order, fine, I'm not on that, but I just pointed out that earlier this issue was not there. Because the same matter has come up, earlier rejection, 3 years was not
my
there.
lord.
Now they are coming up 3 years.
My-
Anyway, I'm not going to
my-
argue
my
further.
lord-
File a contempt. He would have filed a contempt.
That is that in fact, this could have been, I have said, some kind of a contempt is also there, but anyway, they have stated something, they have considered, that is why I have not filed the contempt. That wrongly considered, rightly considered, that has to come up. That is the simple, your lordship, prayer in this case.
Why doesn't the government withdraw the compassionate appointment? It is
Withdraw.
Now it
2017, my lord, we have come with better thing.
compassionate.
Compassionate family pension till the age of 60 years, my lord.
To
That
whom?
diseased,
To
they
whom?
will get the salary.
To whom?
To the here, my lord.
Deceased family.
Diseased family, my lord. Wife or the
Then you consider the case under compassionate family pension.
no, my lord. Here now we have a
No, there's a time limit. Prior to that, the compassion appointment scheme will be there, and after that, only the
till
lordship.
2017, my lord. That compassion appointment thing is there. From 2017, this has come into force. Compassionate family pension. Here,
You very well consider it.
which one, my lord? This we cannot, my lord, because there is
Lordship, this compassionate family pension, the scheme is applicable to those employees who die in harness on or after 1/4/17. He died.
I agree. They have died, but considering the fact that compassionate appointment scheme itself has been taken away, you consider it under the new scheme.
my lord.
When did your father expire?
2010.
10.
And then you did not consider it.
We considered, my lord. We considered not once. We considered, my lord. My consideration is not that we'll give them a job. We considered and we rejected.
The consideration was rejected by the court earlier and said that you do it as per section 15. Now only thing remains where is section 15 by the complaint of.
Instructions as to who is supposed, whether it was complied with in terms of therapy.
That part, my lord. But still that 3 years is, that rejection part is still there, my lord. So unless division bench comes up with something, my lord, either way, my lord, they will pass an order, my lord.
You can consider them under the provision.
New, my lord. Then, my lord, this, that notification is set aside, my lord. Yes, my lord.
We can direct. You may appeal, that's a different issue. We can direct, considering that the case that can be considered.
My lord will, if my lord
If we find that para 15 has not been complied with,
my lord may pass any order, my lord.
so we are compelled to pass orders because of action of the department.
My lord will pass.
See, you have a scheme. You are to consider, you are to implement it. It's a policy of the government to implement it. Now, while implementation, why there are so many litigations? Your orders will have to be such, because you know that any rejection will come to the court.
Oh, obvious, my lord.
So therefore, these rejections must have proper basis.
That is why my lord is there to decide it, my lord.
But we are there to decide, but why do you trouble us always? Why is the department?
My lord, my lord, in a order, my lord, administrative order, either of the side will be agreed, my lord. Even if you pass a order is satisfying, we will try to satisfy, we will satisfy all the persons, my lord. So somebody will be aggrieved, he will come before your lordship, my lord, for an adjudication, my lord. It will be always there, my lord.
Mr.
Lordship, may I do one thing? Lordship, here, your lordship knows that after the SLC meeting is over, the records are with the department only, your lordship. So let us both take the, either one of us will get the
No, no.
instruction.
That, no, it is only our division of one.
PWD is provisional secretary.
PWD no,
All right.
other part, no, other divisions.
All right, your lordship.
No, my
He
lord.
doesn't want you to.
No, my lord. If my,
come to
no,
the
no,
department.
if it is for PWD, I can take, but this is for
No, he
other
said
departments.
the
No.
papers are sent back to the PW.
Send back to departments, my lord, in the sense, we can only say for our department, not for other departments, my lord. If there is vacancy, that is,
you'll have to find out whether that
no,
decision
that's,
is at all
that, my lord,
Basically, your lordship, the SLC or the chief secretary office does not contain any, I sometimes ask them, okay, please send the records or please send whatever the SLC
No,
thinks is written.
we are directing you to find out whether that decision at all was taken. It's not apparent from the IDO. Whether the division into the other department or is it division in PWD only. If it is division in PWD only, then it is not as per law. Whether he still is entitled to an order, we'll see.
my lord will pass order.
He may not be entitled.
Only my prayer is the day my lord passes order, only my lord will quote my judgment. That's it. I want nothing
No,
more.
we undertake to give you the earlier judgment.
My lord will pass any other order, including mine. That's it, my lord.
It is not for nothing that they say memory is treacherous.
My lord.
I can't seem to recollect the judgment.
I think Nagpal also, the original one.
Nagpal, that's right. It starts from Nagpal.
Nagpal, my lord.
Then the same thing has been repeated.
Here, my lord, in this judgment, my lord, Supreme Court has quoted all the judgments, my lord, some 13 judgments. Here, and then after they have come to this.
So that's what we
That,
say.
so compiling all the judgments, my lord, those are all 13
all the judgments have repeatedly said.
repeatedly
that
said,
while
and they
while
said
you were
either on the part of that diluted, my lord, that stretch of
which
period.
you have not stated, unfortunately. This was an option for the
My lord,
department
we
to
have
say.
stated.
Where?
My lord, it is here. Applicant's application was pending for recommendation for more than 2 years, therefore application plant is sports.
Financial hardship.
My lord,
The financial standing.
Supreme Court did not say us to go into financial hardship. Supreme Court said that they could have survived this stretch of period of time, so meaning thereby it is diluted. That is what Supreme Court never said to go into the thing.
Don't read only that particular paragraph. You read the entire judgment.
My lord, I am reading the direction, my lord.
No, that is the only paragraph following the discussion in the earlier paragraph. We heard learned counsel for the party, the respondent. We left right report as to whether the decision taken by the SLC, the minute stated.
Yeah, man. Okay.
Minute
Dated
stated.
23/12/2019.
Sorry?
23/12/2019.
2019, insofar as the writ petition is concerned within bracket serial number 26. Was taken in terms of, was taken with due reference and regard to para 15, clause 15 of the OM dated
OM dated
1/6/2020, 2015. 1/6/2015. the respective standing councils, namely Mr. R. Dhor for PWP, Mr. C. L. Hazarika for
Now 2 and 4.
2 and 4. Will apprise the court the next day with regard to the decisions taken by the HLC so far as the information. Please taken
After 4 weeks, my lord.
4 weeks.
My lord, in between that division bench judgment may also come, my lord. We don't know, my lord. That is also an issue, my lord.
27 May.
Okay.
Deep level, my lord.
Much obliged.
Yes.
I have not received my pension, Your Lordship. I superannuated in the year 2019. There is an order and
Notice has
the
been
respondent
issued.
is
Who
not.
they responded?
Lordship, the matter came up in the year 2020. This is the second time that the matter has come up.
No excuse.
So Lordship, may grant some time for us to obtain instructions.
Standing council GMC will is permitted to complete the instructions and place it before the court after 2 weeks. Mr. Theory appears to the record. Yes.
Okay, what happened? Obliged.
Yes, Your Lord.
Yes.
But in this case, also, my lord, petitioner prayed for my lord family pension after the death of her, my lord, husband. There, my lord, his after 1 month thereafter, my lord, provincialization thereafter, my lord, husband died, my lord. That's why, my lord, petitioner is not receiving anything, my lord. Process has been started, my lord, and my landlord can also file affidavit, my lord.
You have not been granted pension.
Yes, my lord.
Why? Why?
My lord, Lordship will look into whether, my lord, the service of the husband of the petitioner was provincialized on 16/5/2023, and the effect was given on 1/1/2013. And the husband of the petitioner died on 24/2/2013. That means after rendering only, my lord, 1 month and some service, my lord, he has rendered service as official, my lord. By rendering service of 1 month, my lord, whether the husband of the petitioner entitled to the pension, my lord, as per the pension rule.
No, are there how many years of service he is otherwise rendered?
My lord, earlier, my lord, before provincialization is a private school, my lord. School was provincialized in the year 2013. That is the, my lord, he has annexed the document, my lord, which is at Annexer C, page 19. It is in the 2013, the service of the husband of the petitioner was provincialized. So he became an employee, my lord, under a pensionable service in 2013. But before giving effect to the provincialization order, my lord, the husband of the petitioner died. So that means that he rendered only, my lord, 1 month, 24 days service, my lord. By rendering 1 month to 24 service, 24 days service, my lord, and he has annexed.
What is the requirement under the?
My lord, 7 years, my lord, as per rule 142. He has already annexed the document, which is at, my lord, page 37. Page 37, clause 5(2). Death in service not attributable to government duty. Family pension computed in terms of rule 140 and 143 of Assam Service Pension Rule. And DCGR is computed in terms of 135(2). If your lordship look into 135(2), and my lord, he may satisfy that he has completed that, that he has complied with that particular provisions. And anyway, my lord, he has to submit all the papers to the authority, my lord, who issued the provincialization order, not the autonomous council, my lord.
Yes.
Already, my lord, we have submitted all papers, my lord.
No, but the hurdle of 1 month.
Yes, my lord. He has given also, my lord. One order, I have annexed similar order, my lord. Page 45. Page 45, my lord, paragraph 5.
under new defined pension.
Yes, my lord. Yes, in this way, my lord, she is entitled to some benefit, my lord.
No, but what is the provision under the new defined?
That is also under in that provision, so rule 135(2) is applicable. Rule 135(2) say that if there are one or more surviving members of the family, as in items 1 to 3 sub rule 130, it may be paid to all such members other than any such member who is a withdrawal debtor in who is paying by gratuity other conferred rules if there is no pension, 5 years continuous service, my lord, qualifying service. 135, an officer who has completed 5 years qualifying service may be granted an additional not exceeding the amount specified rule 3 when he retires from service and is eligible for gratuity as per rule so and so. So the government is required to submit all these things.
Otherwise, school was recognized in the year 1994, my lord.
Question of recognition will not come, my lord. That it is the admitted position that he was appointed by the managing committee, not by the government or by the council, my lord.
In the
So
provincial,
the provincialization, it affect from the provincial election, my lord. But the contention of the petition of the past service is required to be counted.
What about rule 31? See rule 31.
My lord, now he is coming for the family pension, my lord. Petitioner is coming for family pension, not the regular pension. But the first he has to submit, my lord, she has to submit that the husband is entitled for regular pension and then thereafter the family pension, my lord. But the case of the petitioner is that she is entitled to the family pension.
That's right. So family pension only if the husband is
Entitled to pension, my lord.
Mr. Das.
So he has to satisfy that he is entitled to the family regular pension also.
but here, he submitted representation, my lord, before the authority, page 23, my lord. Annexure E.
Page
23.
So representation, okay, but satisfy
It was received also, my lord. That's my lord, I want to place, my lord. But reference to subject, I have the honor to step few lines, whatever kind consideration and necessary action that, sir, my husband late Dinesh Sutradhar had been working as a headmaster in Vishnu Rava ME school since 92 from the very beginning. But when the school was declared as provincial on 5 January 2013, unfortunately, he had expired on 24 February 2013. So, sir, in absence of him.
So how is this relevant? We are asking you whether you are qualified or not.
Yes, my lord.
After what rules are you claiming? What provision of the rules are you?
If my husband is entitled for regular pension, my lord.
Decide that.
Yes, my authority has to decide.
No.
I have.
So what provision?
Right.
Under what provision?
31, my lord, rule.
So 31, there is an office memorandum. Do you have access to that?
Yes, my lord.
It says 10 years.
10 years. Here he has completed 20 years.
No, 20 years in a private school.
But it was under the government, my lord.
How?
Because recognized school, my lord. That was I have annexed here.
Was it provincialized?
No, my lord. It was recognition was given in the year, my lord, 19.
Is different thing.
Yes, my lord.
Provincialization will give you the status of being a government.
If there is a relation, my lord, employer and employee, my lord, government, and that.
Show us. You argue the matter on that line.
Then I will file additional affidavit with that.
No, enough. What additional? You argue the point. It's a legal
yes,
point.
My lord. My lord, I have not brought this judgment, my lord. One judgment is there, my lord. that if there is a relation between employer and employee by the government itself, my lord, then they are the entitled for all benefits from the government, my lord. One judgment is there, my lord.
Yes, when can you get your judgment?
My lord, Monday, Wednesday, my lord.
Wednesday, all right, Wednesday. First of April. The request of the council for the petitioner matters. Deferred to be listed on first of May, Mr. J. Chotia for Karbi Anglong. Mr.
For
P. N.
chief head and
Sharma
servant.
for elementary. Mr. P. Sharma, P. Chakraborty for pension, Mr. Borpujari for finance. Where is that circular? Do you have that circular for, I think finance will have it. Minimum government service necessary.
English qualifying service.
Qualifying service. On first, yes.
Lordship, if it is not on first, my lord, third, my lord. First.
Third, all right, third. You inform Mr. Dutt.
My lord, I'll inform.
Lordship, here in this matter, I have received some instructions, Lordship, which are essential to bring on record, Lordship. I may be allowed to file an additional affidavit, Lordship. These are necessary for proper adjudication of the matter, Lordship.
Singhania.
My lord.
Singhani.
Yes, Lord.
There any objection to this?
My lord, short date may be 6 months. 28th of
Mr. K.U. Ahmed for petitioner, Mr. P. Upamanu for the senior
Higher education.
Submit that you'd like to file an additional affidavit, Mr. S.K. Das for
respondent for
who is respondent for?
principal director for
Mr. Upamanu submit that. Anyone else you are appearing? I was also appearing for UGC.
my lord.
Mr.
Last occasion, my lord, UGC was directed to produce rules and regulation.
The studying council higher education is leave to bring additional information by way of an additional affidavit. Leave prayed for is granted and to be listed again on 29th May.
My lord, 28th, my lord, kindly.
29.
Highly obliged, Lordship.
Next. My lord, in this series of cases, the petitioners are the retired employees, my lord. They have served as a worker employee for more than 20 years, someone 30 years, and they have retired. During their service time, my lord, they have been given the scale of pay and increment, ROP benefits, everything like other employees, my lord. And after retirement, some of them have been granted the gratuity and provisional pensions also. Now, when the proposal of settlement of pension went to the AG office, my lord, they have returned it back with a comment that whether regulation was done, service regulation. In this regard, my lord, they have filed the affidavit, PH department, and we have filed the reply, my lord. In the reply, my lord, we have annexed certain documents and the orders of the earlier other cases, my lord. May I take your lordship directly to the affidavit in reply, my lord?
Here.
Page number 82 of the Annexure 12A. This is the office memorandum issued by the government of Assam, my lord, in the year 1996. Which says, my lord, may I read, my lord?
Yes.
In the government of Assam circular issued under office memorandum number such and such dated 10/8/1963 of finance APF department, a temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefits as available to a retiring confirmed government employee either on attaining the age of superannuation or on his being declared to be permanently incapacitated
for further government service by the appropriate medical authority. This OM come into force with effect from 1 September 1982, my lord. Thereafter, my lord, another official memorandum has been issued by the government of Assam in the year 2023 in continuation of the earlier official memorandum, page 84, my lord. In continuation of this department OM number such and such dated such and such, it is reiterated that the OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The focus is on 20 years of continuous service. After rendering 20 years of service, if the government servant is superannuated or incapacitated or dead is not the moot point. Any confusion is in this regard is that is against the spirit of OM referred to above. That means, my lord, 20 years, if any employee, my lord, serves in the department in the government of Assam, my lord, and he is entitled to pensionary benefit, my lord. And following that, my lord, in respect of any other case, my lord, page number 85, while granting the benefits of, my lord, pension, old pension to certain numbers of teachers, this finance department, my lord, issued one order, page 85, my lord, wherein they have given the reference of one official memorandum, my lord. It says.
Now, in case of the petitioners, what has happened?
The petitioners are, my lord, similarly situated persons like the other government employees on temporary basis. There was no regularization, but they have been given the graduates regular scale of pay from their initial date of appointment till the date of retirement, my lord. They served in a government establishment, my lord, and they received all other benefits available to the regular employee, my lord. Then, my lord, page 85, paragraph, my lord, after finding second paragraph from the finding, my lord, it says the finance department issued an instruction by number such and such dated 9/6/2009, wherein it is clarified that the work charges and master role employees who entered government service prior to 1/2/2005, but whose regulation was done after 1/2/2005 shall not be governed by new pension scheme may be treated as per existing Assam pension rules 1969, my lord.
Yes.
And thereafter, my lord, I take your lordship to order of this honorable court. A Supreme Court order is there, my lord. I have annexed page number 92, my lord. This is SLP from the order wherein, my lord, the order of the Honorable Gujarat High Court is put to challenge, and SLP was dismissed by the Honorable Supreme Court, my lord. I am reading, my lord, page number 92. It is unfortunate that the state continued to take the service of the respondent as an ad hoc for 30 years, and thereafter now to count that as the service rendered by the respondents are ad hoc, he is not entitled to pension oblique pensionary benefits. The state cannot be permitted to take the benefit of its own wrong, to take the service continuously for 30 years and thereafter to contend that the employee who has rendered 30 years continuous service shall be eligible for pension is nothing but shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state as such ought not to have taken such a stand. In the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondent who has retired after rendering more than 30 years of service. Thereafter, my lord, this is the judgment of the division bench out of which is of the Honorable Gujarat High Court, and as well as the single bench judgment I have annexed, my lord, wherein the petitions have been allowed, directing the granting of pension to those similarly situated employees like the petitioner here of, my lord. And this honorable court, my lord, at page number 102, my lord, from Annex 16, there is another order from this honorable court. I take your lordship to directly. page 121, my lord, paragraph 28. In terms of the judgment of the apex court in such and such, a work church employee whose services has never been regularized cannot be granted pension in view of Rule 3.12 of Punjab Civil Services Rules, which is akin to Rule 31 of 1969 pension rules. Thus, there is a bar for granting of pension in respect of work church employees whose services has never been regularized. The same does not appear to be the case for a permanent or temporary employee. Though Rule 31 of the 1969 pension rules requires that the employment must be substantive and permanent, the petitioner having been made to serve continuously against a sanctioned post on temporary basis from the year 1987 till retirement on superannuation pension on 29/6/2002, the same confers a substantive status on the service rendered by the appellant despite the petitioner being a temporary patwari in terms of the division bench judgment in such and such case. And ultimately, my lord, this honorable court held that the continuous service amounts to substantive service, my lord, and directed for grant of pension, my lord. Honorable Supreme Court, as well as other high courts of this country, my lord, as well as this honorable court in
What are the facts of the case?
Facts, my lord. Facts of the case, my lord, the petitioners petitioners have been appointed as master roll worker initially, my lord. Thereafter, appointment letter I take fellowship, page number 25. Then page 29 is also, my lord, thereafter. Thereafter, page number 35 is the, my lord, promotion.
Promotion to which post?
A pump operator in respect of this petitioner, my lord.
And that is also not a regular post.
That is pump operator. The following departmental, page 35, the departmental staff are hereby allowed to officiate as work charge pump operator in the pay scale of such and such, plus other allowances admissible from time to time with effect from the date of judgment.
So all the petitioners are for work charge.
Yes.
As for pump operator.
Some of the pump operator, other designations are there, my lord.
Yes. Anything more?
My lord, the state of Assam, my lord, has in similarly situated other candidates, my lord, they have issued a regulation order. But in case of Hailakandi district, my lord, what happened actually, their names have been left out from the exercise. Therefore, my lord, there was communications to include the names of the petitioners within that group, my lord. But though the executive engineer communicated time to time, but in the government level, it was not processed further. In fact, the petitioners have been granted the scale of pay and everything. They were also silent about the actual background of the service condition, my lord. As a result, my lord, they continued and served up to their retirement age, they're superannuated. And after retirement, when they have applied for pension, my lord, and pension files have been processed through the AG office, then they have realized that the technical aspect was left. That is the thing.
Which is not regular.
That is, my lord, regulation done in case of, my lord, some of the candidates prior to one day before the date of his retirement, regulation order is there. Page number 59 and 61, my lord. Regulation is there.
Then what is the problem?
That AG has returned, my lord. Whether it was with the approval of the government or finance, the approval was there like that.
Yes.
Lordship, we have pointed out in our affidavit that they were never regularized, Lordship. Their papers were forwarded and they were returned back, the pension papers, because there was no government approval, Lordship. And I have to, Lordship, say this, that engineers are, Lordship, not authorized to regularize anybody, Lordship. Any order of regularization has to be in the name of governor and then also subsequently approved by finance, Lordship. And furthermore, we have also pointed out that in the Upendas judgment, very categorically, Lordship, it has been held that muster roll workers across the state are not entitled for regularization. And that's why in the subsequent paragraph, that fixed pay benefit was given as a consideration, which has been admitted to be given to the petitioners as well.
No. That is wrong, my lord.
And with regard to being left out and others being regularized, that part has also been addressed in the Upendas judgment, saying that whenever those exercises were done, Lordship, those were also not valid. And therefore, others cannot seek legitimate expectations, saying that others have been regularized. So we also need that argumentation has been also rejected by the Upendas judgment. And they are citing the same policy discussed in the Upendas judgment, 1993 and 2005. Lordship.
No, my lord. My land submission is not correct, my lord. Because here we are not getting the fixed pay. As per Upendas has said, my lord, it's a minimum scale of pay is a fixed pay by the government. That is not. We are getting the regular scale of pay since the date of joining 30 years back in the 1984.
Where is the pay scale mentioned?
It's the order itself, my lord. I'm taking your lordship again to the appointment. Page 29, my lord. Order of 1984, 83. At the time, our scale was 370-5-420-7-490. Again, you will find as page 35 as pump operator. Order dated, my lord, 21/1/1992. Which says, my lord, scale of pay 960, 15, 105, 1,520, 18 is given the scale of pay.
It doesn't appear to be correct, Mr. Botapu.
Lordship, it also says temporary in the next paragraph.
They're temporary.
And
that is their whole grievance.
But
They
Lordship,
continue to work. You did not regularize them.
but Lordship, will that give them the right to be regularized? Lordship, that has been
No,
addressed.
not right to be regularized, right to pension.
Lordship,
Having extracted services.
Lordship, pension will have to be subsequent to regularization, Lordship.
You see the judgments which he has enforced.
Lordship, those judgments do not refer to Lordship muster roll workers. One judgment is referring to Lordship a professor, and the other judgment is about a patwari, Lordship, not related to the circumstances of this case.
There need not be, but the principle called out is applicable.
Yes.
The patwari was also on a temporary basis.
Yes, sir.
But Lordship, here Lordship Upendas will hold the field, Lordship.
No.
That's a division bench judgment, and it is.
Upendas is where they claim for the minimum scale of pay.
No, Lordship, the prayer was for regularization, Lordship. It was rejected.
Maybe,
Yes.
but ultimately it was for minimum scale of pay.
Lordship, that was
Here
conceded.
is the scale not for regularization, for pension.
No, Lordship, the prayer was, it was a challenge against the single judge's order by the government, because the single judge allowed regularization. And then that was finally the appeal by the state was upheld in Upendas, but state made a consideration that, okay, we will give minimum pay scale to the workers. And that is what is allowed, Lordship.
What do you think? This is minimum, it is not regularization.
Lordship.
They're not asking for regularization. They're asking for pensionary.
But Lordship, in Upendas, it is also written that they are not entitled for pensionary benefits.
Maybe that this aspect of the judgment were not considered.
It is, Lordship, given very clearly the paragraph. If Lordship allows me to.
Like that, you read the paragraph and show us that this
Yes.
paragraph is applicable, not applicable. So it was, you read paragraph. You read the paragraph.
If Lordship looks at para 23,
Come to straight away para 23. Tell us what is the fact of the case.
facts of the case was that there was a single judge order that regularized the services of muster roll workers. And finally, it was held that that was an invalid order, and muster roll workers cannot be regularized because there are no vacant sanction posts, which is an important requirement under Uma Devi judgment order. And that is why, and this judgment also talks about that from time to time, state governments have also formulated policies to regularize muster roll workers, but those are also invalid, and those are actually violating Uma Devi judgment. But the court refrained from disturbing those regularization. But at the same time, an observation was made that others cannot claim it because those were also not done. Those were done by bypassing the constitutional requirement. And after all this, Lordship, finally at para 23, very categorically the court held that we are of the view muster roll workers are not entitled for regularization of their service with consequential benefits such as pension, etc. And the preceding paragraph, Lordship 22, it is, however, heartening to learn that the state government has agreed not to terminate the muster roll workers who have been working since last 10 years. And the government has also agreed to enlist them and also to give them minimum pay scale. So it was a concession given by the state government at that time. Also.
Are you disputing their appointments
Yes,
initially?
those were never regularized, Lordship.
Are you disputing that they're illegal, irregular?
Lordship, I am submitting that they were never appointed against sanction posts.
That's not the issue. The question is whether their appointments were regular, illegal appointments.
No, I'm not saying they are illegal, Lordship.
The division bench rejected their claim for legitimate expectation for regularization.
Lordship.
Here, there is no claim for regularization. Here, there is a claim for pension.
Yes, but Lordship, pension will have to follow a permanent substantive post, Lordship,
No.
as per pension rule.
It's a permanent substantive post, but they were not regularized. They've rendered services,
Al-
which is why we are repeatedly asking you whether their services were illegal.
They were not substantive, Lordship, because there was no vacant sanction post by the finance
When they were paid
department.
the scale of pay, how that scale of pay could be paid?
At that time, Lordship, there was a practice where workers were engaged by the department, Lordship, without making them permanent or substantive.
Then you acknowledge that you are giving them regular scale of pay applicable to that substantive post,
But those orders, Lordship, also say temporary.
but you're giving them a pay.
Lordship, they will be paid, Lordship, and that is why, Lordship, that muster roll is there. It is a list of workers who are engaged on a temporary basis.
Therefore, my lord, the Assam government issued the office memorandum 1996 and 2003, my lord, in respect of those, in order to cover up those candidates.
And Lordship, those memorandums have been held as invalid by Upendas, Lord.
The right accrued at that point of time. my lord.
You have to go for further hearing in the matter. Further counsel department, heard and something. Be listed for hearing, further hearing. Again, we'll keep it on 17th, 17th of May. Mr. P. Sharma for Accountant General, Mr. Kotakur for, what is it? Which department?
PHE.
PHE. Mr. Talukdar for employment. You are also for accountant?
Yes. I mean, item number 25, my lord.
25. And you are in the other matter?
Item number 26,
Mr.
and 30.
Polita, Medi also. Oh, you give your list, you give your list. You give your list to the court master, item number. This bunch of petitions we listed again on 17th. For further gain.
Hello.
Yeah.
Well, here, my lord, pension proposal of the petitioner was uploaded yesterday, my lord.
Thank you.
Uploaded in the web portal yesterday.
Thank you for pension.
Pension, my lord. Proposal for pension was uploaded yesterday, my lord.
Let the meter be listed after 1 month then. Because it is
submitted
yes.
by Mr. N.J. Khatonier, Learned Study Council, Secondary Education, that the pension proposal has been sanctioned and the sanction was uploaded.
Not sanctioned, my lord. Pension proposal was uploaded.
Pension proposal
Yes,
was
my lord.
uploaded in the web portal on yesterday, date today. So, MS KDB, Learned Council, appearing for the petitioner, submits that matter be listed after 1. Meanwhile, the study council will apprise the court.
Yes, ma'am.
As to the present state in respect of the claims of the writ petition. List after a month.
Obligation.
This matter pertains to pension and other medical benefits payable to public sector enterprise employees. I joined in the service in the year 2007. Before that, I was working with Indian Oil Corporation for 24 years.
Readings are complete.
Yes, my lord.
Readings are complete.
We have filed an affidavit and for the
rule. 22 rule list for hearing. List for hearing in the month of June?
Yes.
Month of June.
Bless
Yes.
Please, the petitioner has received the amount also. The matter was relating to the non-payment of area salary and retirement benefit also. And what is received the amount also.
Yeah.
Received the amount.
You have received the amount. It's submitted by the Learned Council. Rest. Petitioner does not wish to stay further. Accordingly, the dismissed as suppressed in order the pennies that they hide the room.
Hello.
My please, Your Lordship. Well, in this case, my lord, the petitioner's late husband was appointed as an MR labor back in the year 1992, my lord. And subsequently, my lord, he was promoted as work chart section assistant in the year 1994. And he continued to work regularly until November 2019, when he eventually passed away, my lord. The petitioner being the wife, my lord, she filed several applications before the respondent authorities, but she didn't receive any pension or other such benefits.
He was not regularized.
No, my lord. But he was working in a sanctioned post for about 10 years, duly qualified, and there were even communication.
Who's for the respondent? PWD?
Yes, ma'am.
Who's for the respondent?
For the AG,
Mr. C.S. Hazarika. Who appears for PWD? Ms. M.
think-
Das appears for the PWD. Mr. A. P. Sharma for Accountant General. Have you filed your response? No. Let the matter be listed along with this series 25. 25 of the series.
25 to 33.
These are all similar matters relating. Let this matter also be listed on so and so date. On 17th, respondents may file their affidavit in the meantime. 25 to here. Yes, on 17th.
Well, this matter relates to the compassionate family pension matter, and department is
I don't
giving.
think this is a compassionate family pension is in place of compassionate appointment.
Yes.
Probably not before this bench.
Is it so?
This bench is only with regard to transfer and.
Yes, madam, right. And it has been listed before, Your Lord. Any other,
It is the pension, but not the pension under 1969. This is the pension in lieu of appointment, isn't it?
yes, yes.
So it should go before the appropriate bench.
Yes, let it be happen.
This matter be listed before the appropriate bench. Mr. S.C. Biswas appears for the petitioner. Mr. A. Borua,
Correspondent number 6.
Accountant General. Registry to list it before appropriate bench. Yes, Mr. Medi.
Last order, at the last page, is just the direction to sanction the area council of the petitioners. After getting the documents have already been filed on on the last 10th April. 10th April, documents have seen today, they have done nothing.
10th April 2024. Lordship, I will obtain instruction because they were supposed to furnish the necessary proposal along with the necessary documents, Lordship. Now, if they have submitted, Lordship, I will.
We have submitted on last 10/4/24.
Mr.
In the last order,
ARPT appears for the petitioner, Mr. P. N. Sharma, Learned Standing Council Elementary Education. we'll obtain instruction as the present status of the proposal stated to have been present status of the proposal which was required to be put up by the inspector of school Guwahati in respect of the writ petition. Matter be listed after 3 weeks. After 3 weeks. 24th May. Yes.
Please, Lords. Lordship, petitioner have received the affidavit filed by the respondent, Lordship.
You want to file a reply?
Lordship, PWD may be directed to resubmit the proposal, Lordship.
Lordship, in this matter, Lordship, we have already filed our affidavit. And
What is your stand here?
a specific stand was taken that the finance department has not granted its concurrence, Lordship. But Lordship, however, Lordship, in the last order, 6-3,
Which paragraph?
Paragraph 5, Lordship.
And then what happens now?
So that is our stand, Lordship. His service was never regularized, so he cannot be granted pension, Lord.
He was regularized. It was on page number 30 of the petition.
Page number?
30.
30.
Okay, 80 letter.
Here it was written, he will retire on 2022. For pensionary benefits, his service is hereby regularized.
There is some reference of government letter. Mr. Nayak?
Lordship.
There is some reference of government letter.
No, this is an basically, Lordship, this is an order passed by the executive engineer, Lordship.
Maybe, but there is a
And Lordship will kindly see page 85,
no,
Lord.
no, please see page 30 and the reference is made to a government letter.
Yes.
Government letter.
The base, Lordship, and this order was passed in the year 2022, Lordship. So definitely this order of 1978 was not applicable in the year 2022, Lordship.
What is that order?
Lordship, that will be clarified in page 85, Lordship. It will clarify, Lordship. Last page, Lordship.
Last.
Lordship, this is the letter issued by the Accountant General, Lordship. Lordship, may kindly see this paragraph, but necessary, first paragraph, Lordship, third line, fourth line, but necessary concurrence, but whether necessary concurrence of Government of Finance Department has been obtained before regularization found not mentioned. Hence, kindly provide the order of concurrence for early settlement of the case. In view of above, I am to return herewith the pension papers, including service book in original, again with the request to resubmit the same with a copy of government approval order. However, if concurrence of the Government Finance Department has not been obtained, the case may be forwarded through government. The Government Finance Department OM number so and so may please be referred to. So this was an order passed by the executive engineer, who is not the authorized officer to regularize the service of a bus road.
Now, has the papers been forwarded for concurrence?
My affidavit, Lordship, paragraph 5.
You said it is sanction is not there.
Yes, no finance government concurrence, Lord.
But has it been now forwarded for concurrence?
That instruction probably I have to take, Lord.
You take that instruction.
Lordship.
Is submitted by the learned standing counsel, Mr. B. Nayak. An affidavit has been filed where it is pleaded that occurrence of the finance department is paid. Whether the proposal has been now forwarded to the finance department for the concurrence. Is not available. That information is not available with the standing counsel. He prays for further time. And so and so it is for the writ petitioner. That will be listed after
4 weeks, Lord.
4 weeks.
Lordship date may be fixed, Lordship.
After 4 weeks.
Copy to move DD1 number.
27
Lord.
May.
Obviously.
Should we issue contempt?
My lord, the governors accorded approval for creation of post. Now everything, finance is approved. Now the office has been moved to Goswami.
Every time your lordships gives them 4 weeks to comply with the entire thing. Lordships, my humble submission before your lordships is that the lady is in dire straits. Had the husband passed away, at least by this point of time, she might have had some pension in her name. This is unbelievable. They keep playing a ping pong ball between the departments.
Provisional amount has been released. Yes.
3 lakhs rupees, your lordships, which was taken away by the bank immediately because there's a loan in the name of the house. So the bank took away the entire 3 lakhs.
Now what is to be done here?
The
Gone to the accountant general.
yes, the AG will create a head.
Yes.
His
have to obtain instruction because this is coming as a surprise. Can I have a copy of the?
Mohammed, yes, okay. Because the entire service book, a new service book has to be created. Everything has to be new.
Do whatever you want to do.
We are doing it.
But
This submission.
complete the process.
We are doing it.
Lordship, my learned friend's submission on the last occasion was that they wanted to take 1 extra week post Bihu to be able to get the entire thing clear. कहाँ है अकाउंटेंट जनरल का कहाँ है
But yes,
फाइनेंस का दिखा
yes, let the AG obtain the instruction on this.
Lordship, a short date.
Tell us when you can get it.
It's 10 days more.
15? 15 May?
Lordship, a little earlier than that, subject to your lordship.
He says 10 days. So we are giving him another 5 days extra. Or we can have it on 13th.
No, 15 then doesn't make much of a difference. 15 is final, as per your lordship's convenience.
Mr. D. Gogoi, MSRS Chaudhary appears for the petitioner. Mr. D. Gogoi for the public health engineering has placed before this court a copy of the communication addressed to the Principal Accountant General A&E, Assam, for conveying the sanction of the governor of the state for creation of 1 supernumerary post in the rank of Assistant Executive Engineer PhD under the Public Health Engineering Department in respect of Sri Kamal Das, who is the
Husband of the petitioner.
husband of the petitioner. Stop. The learned standing counsel AG, Mr. P. Sharma, submits that he has no instructions, would like to complete his instructions. Accordingly, it is agreed to by the learned counsels for the parties based on 15th of May.
Lordship, perhaps without this instructions, maybe the entire matter may be
The
resolved by
instructions
15th of
will
May.
decide
Lordship.
what steps are they going to take. It is expected that the AG will forthwith
Expedite the matter.
expedite the matter and so that the necessary formalities can be completed within the prior to the next date. List on 15th. You Mr. Gogoi, you give him a copy.
I'll furnish it.
Deeply would like.
I'll let him.
Hold the copy. Yes.
May I please, Lord? My lord, this case, my lord, the petitioner has been terminated. Dismissed from service, my lord. After the retirement, my lord.
After retirement.
Retirement, my lord, just before the 31/3/2023. My lord.
Pursuant to the order of the disciplinary proceeding.
Yes.
So you have filed an appeal.
Appeal, my lord, file, my lord.
Rejected.
That has not been entertained, my lord.
So you are challenging what? The
I'm
entire
challenging that dismissal order.
The entire proceeding. Third. Have you filed your objections?
They have filed the reply, my lord. It's ready for disposal.
Meetings are completed. Matter be listed for hearing. The relevant records pertaining to the disciplinary proceedings and the orders passed thereon in respect of the proceedings initiated against the petitioner, the call for and call for. Let the matter be listed for hearing in the part 2 hearing.
My lord, the petitioner is not getting any pension, nothing, my lord.
You mention it, we'll take up the matter, but the records will be necessary.
Instead of part 2, my lord, it may come in part 1, my lord.
No, part 2. In part 2, because it will
then it will
obviate the requirement of having to get it listed on a fixed date every time. If it is in a part 2, it is there for 1 month. We can take it up on any day. It's for hearing only.
No.
Please get the records.
Lord.
Yes.
Part 2 of the in the month of, my lord, next part 2 list.
In
my
the
lord.
month of May?
Next, in the next part 2 list.
Or in the month of June? In the month of June.
No. Obliged.
Wait, please. No, she will kindly go through the last order path, right? What there was some instructions or so forth. Basically, the matter relates to transfer of a female teacher on safety and security ground.
Yes.
Initially, as per just the facts of the matter, initially she was given the transfer, but she was not allowed to join, so court case was filed. And during the court case, the other person who was sent in her place, he also came up, and ultimately on a technical ground, the matter was sent back to the authorities to reconsider. And it was reconsidered, and again, it was found that under the safety and security, I'm entitled to the transfer. Then
Yes.
they don't have a post now. That is the issue, and whether some post
In
is
Kamrup
available or not,
or
that is.
Metro, any vacancy available?
No, Lordship. Today morning, they sent me one WhatsApp message that right now, no vacancy is there.
So where
Initially, Lordship, however, the petitioner was given option, Lordship. She was asked for preference. 2 posts were shown to her. Either you can join this post or that post. She rejected.
No, that was in Dibrugarh. One
2
in
posts.
Dibrugarh.
One in
Dibrugarh and
Dibrugarh.
Morigaon.
No, it is not necessary that he has to be given
now,
posting in the.
Where was he posted?
Uh,
Where was your transfer order?
No,
No
initially I
transfer
was
order.
posted here in Guwahati. And the person from Guwahati was transferred to my place. Then that was challenged.
No, where is your place of posting?
My at present posting. That is your lordship the place.
More epidemic.
Just a moment.
Inexorable naikya hoye jaye.
No, hey, that জায়গাটির নাম তো মোৰ মনে নেই। At the Kadong High School in Borpeta district.
Borpeta.
Kadong High School in Borpeta district. This is basically a remote area, about 12 kilometers from the Borpeta town. And being a lady and at that moment she was pregnant and now she has a very small child. So she sought for the transfer on the ground of safety and security, which is there as per the rules. So she was given a transfer. The transfer order was issued. She was given in Guwahati in particular school, and the person from Guwahati was transferred to that Kadong school. Then what happened? She was not allowed to join in Guwahati. The person did not vacate. Then she came before this court challenging that I was not allowed to join in Guam. Then what happened? The other person also, he also came and filed a writ petition challenging that the order is not correct, technically not correct, because there has to be an approval. That approval has not been taken. This court has set aside that the earlier order, saying that you reconsider on the ground of safety and security afresh and follow the procedure and approve it. Now the second time, the same procedure was followed. I made the application, they have processed the same. This time they have given me the safety and security certificate and the approval was also. Now after getting the approval, I sought for the transfer. Then this time what they did not put me to the earlier school. Now they said you go to Dibrugarh, in a particular school in Dibrugarh and one Moriga. That option was given. I said that was earlier I was given here, you give me the same.
Earlier order?
Which order?
Earlier order?
High Court order.
High Court order.
High Court order, your lordship will find, starts from page 39. And the relevant part is at page 51. The long order, so page 51. The paragraph 18. I'll just read that. Taking into account the applications so made both under the manual mode as well as on the online mode, the petitioner so and further taking into consideration that ground exists for transfer in terms of Rule 9, as has been certified by the Additional Deputy Commissioner Borpeta District. In its certificate dated so, this court directs the Deputy Commissioner of the Borpeta District to verify as to whether any of the grounds mentioned in Section 9 still exist in case of the petitioner, and if it is so exists, refer the same to the competent authority under Section 5(2) of the Act of 2020, and the competent authority thereupon is further directed upon such reference being made by the Deputy Commissioner to consider the proposal of the petitioner. In the eventuality, the competent authority deems fit, the said competent authority shall recommend to the appointing authority for issuance of the transfer order. The appointing authority, upon being satisfied with the recommendation, shall pass appropriate order for transfer. The said exercise may be carried out in terms of Section 9 of the Act of 2020 or Rule 11 of 2022 as expeditiously and not later than 45 days from the date of certified copy. Subsequently, thereto, your lordship, the certificate has been, I made the applications. The certificate was uploaded, that your lordship will find at page
So now there is no
page
vacancy.
52. Now, what happened, your lordship? My case is basically that. Earlier, you have given me this transfer to Guwahati, whichever school in Guwahati, you give me to that school because the other person was supposed to go there. And only on that
Obviously,
technique.
he doesn't want to go.
No, that was there. Earlier also he was not there, but I was given. It was not that earlier I was not given. I was given the transfer. And that transfer was on the only part that competent authorities approval was not there. Now,
Why are you not giving a transfer in the school?
He will again come to this honorable court. Lordship. He will again take an order.
but this time he cannot come up saying that this technical ground.
Earlier, Lordship, one transfer order was passed in her favor. But the other person came.
So now you are trying to find out vacant post.
She was even given preference, Lordship.
In vacant post?
Yes, Lordship. At that point of time, when the speaking order was about to be passed, Lordship.
I think that's a valid ground because in order to curb litigations, unnecessary litigation, they thought vacant post would be available, you go there.
No, that is true. But I'm saying that, but the question is, it is the whole transfer was on the ground of safety and security. It's not a
Safety and
normal.
security, it is not that Dibrugarh is not safe. only her home district is safe. That cannot be the argument,
No,
Lordship.
no, my argument, my learned friend may have said that there is a lady with a small child. See, that is the reason. Otherwise, what's the problem in going to Dibrugarh? She would have gone there, but the issue was only that. And it is not a normal transfer, safety and security. And basing on that, she was given here. And the same school, and the court's order was also very specific that you pass the order, transfer order, considering that follow the rule 11 and rule 9. So rule 11, rule 9 now follow, but a transfer was given in another place. He is also correct that he may again come, but this time, even if he comes, earlier he said that yes, the competent authority approval was not taken. That was his ground. Now what ground he will take is also an issue here.
That we don't know what whether he'll come or not.
That is also all your lordship presumptions.
Lordship,
He is there now.
Lordship is page 50, my lord. Para 15, 1-5.
You are a
He is the other person.
Other person.
We have implemented him also.
Why?
No, this was on the directions of the court. Because we wanted to come here.
Page 50, para 15, my lord.
Page 50, para 50.
My lord. May I read, my lord? Consequently, in view of the setting aside of the immediate transfer order, the order of the release dated therefore known as in the eye of law. Taking into account the petitioner in devolution number was released in view of the improved transfer order dated which has been set aside, and the said petitioner has acted on the basis of the said order issued by the official, and the court having rendered the release order dated non-end. The petitioner devolution of shall be deemed to have been continued in her post as the vocational teacher of Kadong High School, Borpada, provided the petitioner joined the Kadong High School, Borpada, within 10 days in the instance order, my lord. Present petitioner, my lord. Accordingly, he joined here, my lord. Joined there. And now I am in my original place of posting.
No, both are in the original place of.
No, but
Then
where is the right for you to make a path that must be put in it?
no, there is no specific right. But basically, my prayer was earlier prayer was also answered in my paper, but some technical because of the competent authority was not taken. So I wanted that this also should be made. Now at least there is no post. That is what
Your
they are
prayer
saying.
is to take a decision to transfer you to the home district.
Or I also said made in the last occasion. I also made
Lordship,
that if
kindly
it is
come
not
to
the
page
home
75,
district,
Lord.
at
Page
least some
70
nearby district. That's what I
Page
said.
75, Lordship.
From nearby district also is possible if
Page
it can be
75.
accommodated.
75.
Page 75, affidavit, Lordship, just above 5 lines, above paragraph 12, Lordship. The said speaking order. 5th line from the top, Lordship. The said speaking order dated 18/7/2022 has dealt with each and every issue relating to the instant case meticulously and in great details, fairly stating that in future, if any vacancy arises in retail trade that to which she belongs, Lordship, within the district of Kamrup or Kamrup Metro, she may apply for transfer against such vacancies as per now.
Yes, on
Where,
this
where
basis.
is the order rejecting her transfer now, which is challenged here?
No, see, now
No,
she
there's
has-
no rejection.
There is no rejection. You
Because they
consider,
don't have a vacancy now here.
you consider and
No, when vacancies will arise, Lordship, in her
where is
preferred
the
district.
where is the requirement of this safety security? Where is it?
It's section 9 and 11, Lord.
Of the Assam Elementary Education Teachers Regulation of Posting and Transfer Act 2020. I have quoted that in page 8. And on the last occasion, your lordship,
Is
on
it
the
available in this book? Not available.
Yes, it's there.
Is it?
Transfer and posting.
Assam. No, I have also annexed that. Not annexed. I have in
In the beginning itself.
page 8. I have quoted that.
Yes. What is that section?
Section 9.
11.
The building was normally set up today, not like here.
This is only for the female teacher,
Safety and security.
of female teacher.
So you have to apply to the district commissioner of Borpeta. It is the district commissioner who will recommend.
It's
Yes,
an
deputy
online process.
commissioner recommend. This time they have recommended.
They have recommended. Where
But
is the
they
recommend?
did not give the specific which place, but they have
Actually,
recommended.
where
That
is the
recommendation, your lordship will find at page 60.
60.
No, sorry, I think it is. Sorry, page 56, 56.
No, ঠিক আছে, 62
না, 56 of the section 9 click
62 আছে।
62 second upload করা তো একটু প্রথম দিয়া।
Now, this is again 1-year-old certificate.
56, no, the matter was continuing for this period.
Whether this is there a limitation here?
No, there's nothing called limitation period.
Okay, you consider on the basis of.
Look, this has been considered, Lordship.
Then-
Only thereafter the speaking order was passed.
Where is that order? That is what we wanted to see.
Yes, Lord.
That is at page
Speaking order dated
63, I think.
18/7/2023. And affidavit of available in my.
Right, wait. Yeah, this is at page 63 of the report.
62. No, yeah, before that. 18/7 এখন আছে নহয় 18/7 খন মই এফিডেভিটত লগাইছিলো এখন নাইকিয়া কৰি দিলো মই এফিডেভিট নাই দিয়া মই চাইলে নাইকিয়া মানে ভিতৰত লিখি এনেকুৱা কিয়
This consideration is on in respect of non-availability of vacancies, right?
Yes.
Been rejected. But if you look into section rule 9, section 9. Section 9 says in case of the recommendation, competent authorities shall immediately consider and recommend for issuance of transfer order. So you have to take a call and give her a transfer order.
But
with or without vacancy.
Without vacancy, Lordship.
We don't know. You'll have to issue an order. That is what.
But that is the only issue, Lord. And she cannot be transferred to other posts because she belongs to a particular trade, Lord. So that is why in the speaking order that option has been given whenever there arises any vacancy in her home district, Lordship. And if she applies, it will be considered.
No, but that is not the mandate of the Act. Act says safety security. There has to be a recommendation. And the DC has recommended. Once the DC recommends means there is a apprehension of safety and security.
Lordship.
Now under that circumstances, you can't say you be there until vacancy arises, which may never arise.
Yes, that is there. That is
the recommendation will carry no meaning. So there has to be some order.
Transfer order. They have not issued any
Generally,
transfer
what
order.
happens, Lordship?
They have given you an option. You
They
did
have
not
given
accept
option, but they have not issued any transfer.
They wanted you to. They wanted to be nice to you by giving you an option. You refused that nicety.
And that was on my initiative. Lordship. The department gave him that opportunity.
Oh, you want a transfer, then you want a place of choice of posting, and you want it in your home district. How is that possible?
At that point of the vacancies were available, although not in her home district, Lordship.
No, the second option that I
Okay,
said,
you
he was
think
there.
about it. We'll
No,
come
I
back
said on the last occasion also that.
Lordship, although we have given assurance to her, Lordship, whenever there arises any vacancy,
Then
we'll definitely
can,
consider.
rather than keeping it pending.
We are not keeping it pending.
Yeah, dispose
We
it
said
off.
we'll come back at 2. We are not keeping it pending.
It can be disposed of.
You may Offer him a cup of tea to see.
Obviously.
Lordship, at 2, Lordship, I have another fixed matter.
You ask your colleague to be present, whoever is there.
No, I will remain present, Lord.
Ah.
Lordship will take little later, Lord.
All right, we'll take it up at the end of the list then.
My business. My lord, in this matter, my lord, I apologize, my lord. What happened, my lord? I missed the case. My name is not shown in the court. I am for the, this is actually handlooms case, my lord. And my name, either SC handloom or my name is not there. So miss, my lord. Among my lord.
It's
It- 929.
No. That name of that next time. Weeks further time. Further trade that name that the name of the study company. Like you reflect weeks or
Deeply replacement.
and it's built. Rates being directed like the thing that
Deeply replacement.
May fix that, Lordship, because he retired in the year 2017 itself.
22nd.
Obliged.
May praise the Lord. Lordship, the respondents were required to file their affidavit. This matter, the fact was that Lordship in 2017, we had submitted an application for VRS. Now, Lordship, that was not acted upon. No pension was released for 2019. We preferred a letter.
Yes.
Let it, Lordship. Lordship, we need some time, Lordship, to take instruction, Lordship. Till now, instruction have not been received, Lordship. From Secondary Education Department, Lordship. Lordship, 1 week or 2 weeks time.
Sir?
T. Thakuria, Lordship.
Pray for further time.
A. Chakraborty.
N. Chakraborty.
A. Chakraborty. Order faster. But date may be fixed because there is no pension since 2007.
27. 27.
Not obliged.
Obliged.
May please, Your Lord. This matter relates to arrears salary, Lordship. Petitioner for a particular period, Lordship. In that time, he was undergoing treatment for tuberculosis.
Yeah, what happened? What instruction?
Lordship, as per, I don't have at the moment written instruction, but telephonic instruction is that the period for which the petitioner is seeking for this arrear salary is even unauthorized absence. So Lordship allowed 2 weeks time. In the meantime, I will have the
But you'll have to pass some order.
Lordship. So I will file, I will bring some written instruction, complete instruction, Lordship.
There are
May I pray for a date, Lord?
Lordship.
Obliged.
sorry, first June, third of June. Third of
May it please, Your Lordship. In this case, my lord, your lordship was pleased to issue notice
on 18/3/2024. No, till date, no response has come, madam.
Yes.
Lordship, instructions are awaited, your lordship. Okay.
You suspended him after 7 years.
7 months, your lordship.
Not
After
7 years, madam, it is wrong.
7 months.
7 months.
Okay,
Hmm.
3 weeks further time.
Your lordship.
Read their remedy. It's after 3rd of June. 3rd of June.
Lordship.
Problem. Oblige, your lordship.
Oblige.
Lordship, before my friend starts, Lordship, I'd like to say that, Lordship, my friend has submitted an additional affidavit, Lordship, in this matter. So the copy was inadvertently served to the government advocate, not to the department, Lordship. So I have gone.
But in any case, we are not entertaining your learned friend because he is not properly dressed.
Next.
All right. Matter be listed when
3 weeks.
after 3 weeks.
2 weeks, Lordship, 2 weeks. I'll file, Lordship, reply to the additional affidavit.
Mr.
Heir Provisional.
Heir Provisional, praise for and is granted 3 weeks time. File reply affidavit.
To the additional.
The additional affidavit file. Sir, and appears for the- we are granting him 3 weeks time to file reply to your additional.
Can it 2 weeks time maybe
2
granted?
weeks,
at-
2 weeks,
2 weeks.
2 weeks.
not 3 weeks. 2 weeks. 2 weeks time.
No.
We have already passed the order.
No.
Just after 2 weeks.
No question. A copy of the.
Now,
Now you serve.
Obliged.
The respondent has filed the wakalat, my lord. They are supposed to file the affidavit. Respondent number 4 has filed the wakalat, my lord.
You have filed. You file your affidavit.
Lost.
It is submitted that Mr.
J. Abbas.
J. Abbas has filed power to enter appearance on behalf of
Respondent number 4.
respondent.
Number 4, your lord. 4
Number 4. He prays for further. He prays for time. He prays. He seeks liberty of the court to file the necessary affidavit.
Continues to continue. Lord.
Prayer made is allowed as it is not objected by the current council. Some interim order is there.
Yes, your lord. Yes. On 23rd of 5th of August, your lord.
On
5th of August 2022.
6th of August.
Yes, your lord.
Otherwise, Lordship can dispose of also.
Let them file the affidavit, your lord.
Interim order passed on 6th of August.
Much obliged, your lord.
Investment.
Read that.
Deep level.
Maybe Lordship, madam, this case was earlier dismissed for default due to oversight of not looking into part 2 hearing list. On the same day, another case was dismissed for the same ground, and that has been restored, my lord. That Lordship may kindly see the order.
This is what? This is the miss case.
In miss case. Miss case and the main case has been listed for hearing. This is the 2 orders I have given. Exactly on same day, same reasons, the case was dismissed for default.
Heard. For the respondent. Elementary education. Any objection? For restoration.
On that day, they did not raise any objection. That is also written in the order sheet. In the order sheet, they did not raise any objection. That is also recorded.
Which order?
In MC, that I had given two orders, LC MC order.
For restoration, you don't require precedent. Any objection? Certainly no. I has been filed for restoration. WP 705. That was at the part of both part. Matters were called up. All the matters were dismissed. Right. Council appear. Deliberate. Attempt by council. Meeting all part. Prayers made. I hear. But around the are yes. Step. Step. Five. Step. Sufficient step. Deliberate. Act of part. Eight. Part of the council. Respect all the part. That all then I accordingly allowed it. I raised it.
I oblige.
Well, this matter relates to payment of arrear and current salary. Current salary, started to be paid now.
Lordship, here we require some more time because it is under process, your lordship. Some more time may be granted,
Order 3 weeks time.
lordship.
Sorry, please.
And it may be recorded, but there is under process submitted by the, made by the.
Huh?
Well, it may be recorded that matter has been under process now.
Submission of the learned council. Order. Reported. The learned council submitted for by the time. Okay. Right. Prayer made. And after 3 weeks.
The date may only 27 May.
27.
May.
27.
27 May. Problem.
It's not 27.
Oblige. Item, my lord, service has been completed for respondent number 7 and 4 to 7, my lord. This matter relates to The non-payment of arrears salary, including the suspension period.
as per notification. Any instruction?
Lordship, we need some time, Lordship.
Yes. You are referring to the
4, 6, and 7.
I am for 1, 2, and 3.
Right. 6 and 7. The respondent further time. It's on 29 of the 29 May.
Madam.
Hospitalization.
Yes, what happened? Where is the council?
Junior chair.
Yes, where is the council? You can't wait for it. Where is the respondent counsel? Where is Mr. Nayak? Where is Mr. Nayak? Let it be on first of May.
Fine.
Let it be listed on 1st of May. The order of it.
After 7 May, madam.
Your adversary is not available, so we thought we'll adjourn it today.
Oh, he is not there.
We don't see him. What about 1st of May?
No problem. First May last.
Difficulty, madam.
Hmm?
I have some problem.
Put it on, your lordship can have it on 2nd of May. It's a Thursday, can be disposed of. Because the issue, only 1 point.
Second?
2nd May.
Second or third?
Yes, madam. Third, madam.
Third of May. List on 3rd May. We thought we'll dispose it off, but
Yes.
in his absence may not be proper.